51. This matter was fixed for filing of written notes of argument by the petitioner. Meantime, client has obtained change, while we will be seeking for at least 3 weeks' time to file the written notes of argument.
So let the matter come.
Yes. In the meantime, I have taken out an application for transposition of some of the petitioners to the respondents. I'll serve my other side, but that keeps it after vacation. My junior will be there.
But let the matter come
Yes, yes.
equally thereafter.
May I permit to mention for
And sanction on restoration.
Have you served notice? You serve notice on counsel.
Lord, the
Dated 28th August, court number 20. But the pendency as the distribution, but warrant has been issued. So very much urgent, but she kindly died to it. Very much urgent, warrant has been issued.
Where is the order that the warrant has been issued?
That has not been annexed. I shall give the, I shall pray for supplementary evidence. But the fact is this,
Sir, many matters are there in the list along with the matters that has been allotted
yes.
in criminal division. So, you people will not appear. No one.
Go to the court.
Next.
may I have your lordships kindly leave to mention, Lord, item number 96 of yesterday's order.
Not now, sir.
My lord, your lordship.
It must be there in the list.
My lord, last days, my lord, yesterday's list, my lord, an advocate from the office of the advocate on record was appearing, but your lordship has passed an order, my lord, that the appeal be dismissed for non-prosecution. My lord, an advocate was present. My lord, perhaps your lordship was a...
If you send somebody. Sir, it has not been listed.
To kindly reconsider that, my lord. My lord, kindly.
Your lordship, item number 240. They did application for stay. And the matter will come up serially, then only mention. Call the list.
May I have your lordship's leave to mention 2 matters for listing as application, my lord?
Deposit. Next. It's fixed on 26, my lord.
Your lordship,
Yes,
this is
what
an
is this?
This is the application for restoration of the application of the WPA matter. Affidavit of service is
Have you served notice upon your other side?
the affidavit of service.
Who is your other side? Who is your?
Sayanton Bose is on the other side. National Seed Corporation.
When was it dismissed?
It was actually dismissed on the 3rd of October, but then we had filed a restoration application subsequently. Because of some defects, we had to withdraw the application from your lordship's court itself. The order is annexed on Annexure B. There's an order of the
There is,
30th of June.
there is a delay in filing the restoration
This is
application?
a delay, your lordship. The liberty was taken from your lordship's court to file afresh. In the consideration of that, there is no delay in filing the matter. Your lordship's order is on Annexure B. It is on the 30th of June, 2025. Matter has been filed within time, your lordship.
So how many times do you intend to get the matter dismissed and thereafter
Your lordship,
restored?
it was not our fault, your lordship. The erstwhile lawyer didn't even inform our client that he could not be present on that day.
You are the new advocate.
I am
Have you filed the wakalatnama?
been done.
The learned advocate representing the petitioner? No. File the affidavit of service, let the same be kept on record. None appeared to represent the respondents. Despite receipt of the notice. You know the advocate on record of the respondents?
Mr. Sayantan Bose, yes, your lordship, I know.
Find him out. Ask him to come. Next.
I for the respondent, you Mr. HON'BLE.
Well, at last occasion, your lordship directed to file report regarding the payment of provident fund amount as well as the gratuity amount.
So yesterday, nobody appeared from your side? Your report is ready?
May I get a copy of the report?
You give him a copy of the report filed by the learned advocate representing the respondents, be kept on record. Now, what is the report, sir?
Stated, my lord.
Loan amount.
Yes. Well, whatever has been disbursed, my lord.
Yes.
That's that page 2, my lord, paragraph 4. And out of which, my lord, loan amount has been deducted. And EPFO pension, my lord, the substituted petitioner is.
It has the substituted petitioner,
Yes,
the wife,
wife.
has received it.
Yes, receiving, my lord. EPFO pension has been the provident fund pension. The employee was receiving, thereafter the wife is receiving the family pension. Provident fund amount has been received by my client, my lord. Only provident fund. I have the instruction that provident fund amount has been received.
Then what is your prayer in the
My lord, may I come back, my lord, after going through the report, my lord?
a copy of the same be served upon the learned advocate representing the petitioner, who is to file exception to the same, if any, on the next date of hearing. Next date be fixed on 21st of November. Next.
22. Not a big shift. I'm appearing on behalf of the Damodar Valley Corporation.
Yes, sir.
Last application. Yes, report. OP has been served along with it.
Sir. What does the report say, sir?
Report says, my lord, the district, my lord, the district magistrate has no role with regard to the appointment, and my lord, this type of petition has already been decided by the division bench that the petitioner is not entitled to any job under the compassionate.
Do you have the copy?
Yes, I have got the copy. And answering respondent is the my lord, Damodar Valley Corporation.
Yes, ma'am. I've stated in my affidavit. I don't know why it's there on that order. But Lordship kindly consider one thing.
Yes.
That's land loser. But
Yes.
under the land loser category, already, my lord, there was a scheme for giving appointment of 500, my lord.
Yes, that was completed in 1985.
No.
Thereafter,
Probably my learned
well, that has been decided by the division bench.
my lord,
So, sir, it's better that you give him a copy of that order as well as the copy of the report.
because, my lord, already the matter went up to Supreme Court. There, my lord, I got an order for giving appointment, my lord, in 2009 or 10.
Against this order.
This
I don't know,
is the judgment of 2025, 9th June 2025.
For that, my lord, there was judgment of Supreme Court on the basis of which appointment was
Okay,
given.
on the next date, you get that judgment also if it considers,
Lordship kindly
if it has
consider
considered the same prayer in your petition.
No,
Lordship kindly consider the petition as
1704
prayer. Kindly consider.
So that's exactly what
After
I'm saying.
2 years,
of 2025.
Report filed.
land was taken
Report in
19.
the form of an affidavit filed by the respondent, filed on behalf of respondent number
11 of
7 and 8 be kept on record. The learned advocate representing
11 of 2015.
respondent number 7 and 8
Yes.
submitted that the relief claimed in the
appellate-
instant writ petition
the order the
had been ultimately decided by the division bench of this court by order dated 9/6/2025. A
11
copy of the
2015.
judgment pronounced on 9/6/2025
4 of 2015
placed by the learned advocate
Order date
representing
29th
respondent number 7 and 9 each be kept on record. Next date be fixed on 21st of November for filing exception to the aforesaid report by the learned advocate representing the petitioner, if any.
correct.
Full stop. Sir, you please enter your appearance. Next date. 21st of November.
21st of
November.
November.
Because he says he has a Supreme Court judgment. Let him
My lord,
please
that
stand.
my lord, one Supreme Court
Right.
judge has also been considered in the division bench. Supreme Court judgment has also been considered.
Let's see, sir.
Let me see that if your lordship can direct.
I have directed you to, there's an order that you can file an exception to the report, if any.
My lord, report has been submitted long back.
তুমি তো আর এগুলো বলোনি রিপোর্টে
25.
25
At 25, I'm appearing for the petition. My advocate on record is my lord Kunal Ganguly. My
report
Yes.
Yes.
My lord, here this is also my lord, their report is here.
I have report filed the exception to the report, my lord.
Yes.
The last occasion.
Yes, tell me what is your,
My lord, here the appointment is without government approval. The government has no liability. Gram Panchayat, if his own capacity gives such appointment to or seat one homeopathy doctor and others, permit
Seat
to
one?
give.
My lord,
My lord, this is homeopathy appointment of homeopathy doctor. How it can be done without approval from the government
My
of
lord,
the
in the-
authority? The Pradhan has no authority. I have submitted the report.
But in the year 1988, my lord, this memo was, my lord, published by the government of West Bengal. But my client, my lord, has been, my lord, in service since 2000 by memo, my lord. Subsequently, my lord, I indicated that there are a lot of resolution. Kindly see page number 28.
Resolution by the panchayat, not from the government. The resolution by the, let the panchayat, if the
Sir,
panchayat-
if both of you, which page?
But page number 28. It is written
What
by
is
the
this?
panchayat. Written in Bengali, এত দ্বারা শংসাপত্র দেওয়া হয়ে যাইতেছে যে গোপাল বসাক, my client, my lord, such as গ্রাম পঞ্চায়েত, থানা such and
So
such,
this is not a notification or a,
no,
issued by the panchayat authority.
what I am submitting that
He
is
has been in
matter.
service since 2000.
now what has happened?
But
He has
my
been removed.
representation, my only prayer to consider my representation, my lord.
What is your representation?
My lord, representation is in page number,
তো ঠিক আছে না না একবার প্রিন্সিপাল সেক্রেটারি
my lord, page number 30,
Page number?
30, 30.
না ঠিক আছে এই নাম্বার 30 my lord
My lord, I applied for
Receipt
the,
of the application.
yes,
submitted.
I applied for the post of the homeopathy that has been received, but thereafter, my lord, they are silent. My lord, prior to that, my lord, I filed my representation.
no, where is the content of the representation?
My lord, page number 26. My lord, page number 26. It is the written by BDO to the district magistrate, prayer for approval of the homeopathy doctor at.
So where is your prayer?
No,
Where
it is
is
not
his
my.
case?
It is prayer. It is the prayer of the block development officer to the DM.
DM is the appointing authority.
No, the director of
There has to be a sanction post.
sanctioned.
It is not sanctioned, madam.
It
is not-
wasn't.
Not
It
sanctioned.
is not sanctioned, madam. But if I go through the petition, madam, I'm coming from the
Okay.
beginning of it, madam. Madam,
Sir, I'll fix it for orders.
My lord,
madam, kindly fix it for orders.
For the submission of learned advocates representing both the parties. Next date we fixed on 18th of November for orders.
my lord. My lord, let the both matter be on the same date, my lord, on 21st.
21st.
My lord,
Okay, 21st.
My lord.
21st.
deeply obliged, my lord.
Next.
Lordship, Aparna Banerjee is appearing in this matter for PF authority.
Milords, I appear. Milords, my writ petition, Milords. Today is fixed for hearing, Milords. May I just indicate, Milords? The challenge, Milords, the writ petition has been filed challenging orders whereby, Milords, the respondent Employment Provident Fund authorities have come to the conclusion that Employment Provident Fund Act 1952 is applicable to the petitioner on the ground that, Milords,
What is your prayer?
Milords, my prayer is that these orders which have been passed, Milords, by the Provident Fund authorities be quashed, because, Milords, I am not an establishment to which the Employee Provident Funds Act will apply, owing to Section 16, Milords. Section 16 of the Employees Provident Fund Act, Milords, exempts a class of establishments, Milords, which are registered under any central or state act and are enjoying contributory pension and or old age pension benefits under any scheme under any particular act, Milords. That is Section 16(1) subsection 6. Now, Milords, I am an entity which is registered under the Society Registration, West Bengal Societies Registration Act, Milords, which is a state act. And, Milords, I am also paying, or I have also created a fund, employee state insurance fund, Milords, in terms of Employee State Insurance Act. And, Milords, I am enjoying benefits of contributory provident fund under that act. So, Milords, therefore, in terms of Section 16(1)(c), Milords, I am an establishment who should be exempted from this act, my lords, and this act should not apply. My lords, may kindly take section 16 once, my lords, of the Employees
So
Provident.
you are Born Hooghly Convent School.
My lords, I am Born Hooghly Convent School registered under the West Bengal Registry Societies Act, my lords. West Bengal Societies Act, my lords, and
What did the respondent authorities ask you?
Yes, my lords. My lords, I'll just indicate. My lords, this is the third round of writ petition, my lords. My lords, the first writ petition was filed, my lords, when I was declared to be an establishment under the Act without any order. So, my lords, I filed the writ petition. This honorable court was of the view that without passing any order, you cannot make the act applicable. They were directed not to take any coercive steps. Thereafter, my lords, an order was passed by Assistant PF Commissioner coming to the conclusion that the act is applicable to us because as on the cutoff date, as per them, which is 1st August 2005, my lords, I had 20 employees, 20 casual employees, and therefore the act is applicable to me. And my headmaster, who's the petition number 2, has also given an undertaking to that effect. On that basis, my lords, he came to the conclusion that since I have 20 employees who are casual motivated employees and have been paid wages in terms of the act, therefore the act applies to me. My lords, I filed the second writ petition saying that as on 1st August 2005, name of one employee has been repeated twice in the salary sheet, and therefore the act is being applicable. Otherwise, if that name is removed, there'll be 19 employees. On this ground, my lords, the second writ petition was dismissed, saying that this point was not taken before the commissioner, and since the petitioner has a statutory appeal or statutory right of review under section 7A of the Provident Fund Act, my lords, therefore he should avail that remedy. Now, my lords, I was given liberty to avail the remedy. My lords, I filed a review application. My review application was rejected by the Regional Provident Fund Commissioner, saying that the act is applicable to me because from the salary and register sheets, it transpires that 20 employees have been paid. As on 1st August 2005, there were 17 employees of the school and 3 casual employees. All 20 have been paid. My lords, I am not getting into that aspect of the matter. My lords, my lords, I am for a moment, my lords, I am assuming, not admitting that there were 20 employees and 20 employees have been paid. My lords, my case before your lordships is, my lords, in terms of section 16, my lords, any establishment which is registered under a central or state act and, my lords, is enjoying any contributory provident fund benefits or old age pension benefits under any act, then, my lords, this act, the Employees Provident Fund Act, should not apply to such establishments. And, my lords, since I am registered under the West Bengal Registered Societies Act, and, my lords, I'm also maintaining an insurance fund under the Employee State Insurance Corporation Act, and, my lords, those benefits are being enjoyed by my employees, and, my lords, I've disclosed those documents. Therefore, my lords, this act should not apply to me. My lords, may I just show a couple of documents to your lordship?
Not today. Now, who is representing the Regional Provident Fund? Sorry.
Apurna Banerjee,
Where is she?
book number 12.
Ask her to come. Ask her to come. Next.
I'm for the petition. I'm filing my reply, my lord.
Affidavit and reply filed by the learned advocate representing the petitioner be kept on record. Sir, have you served them a copy?
My lord, only one thing, my lord, the affidavit in opposition taken out on behalf of the district judge. I am representing state respondent number 1. I may get a copy of that in case any. My lord,
They're,
sir, my lord,
they are this OBC or something.
yes, my lord, that is the dispute.
Yes, madam.
The,
Did they file any opposition?
no, my lord, my lord, on the last occasion when this matter was taken up for hearing, your lordship has made an observation that let us go through the affidavit in opposition filed by the district judge, because he or she is the
Yes, ma'am.
chairman of the selection committee. In case any accusation is made against the state respondents, my lord, the state respondents will be at
Yes,
liberty
yes.
to take out opposition. So in that view of the matter, my lord, since I have received this, my lord, lordship may kindly.
The opposition is without any annexures.
Without an answer, may I submit? But the
Affidavit in
opposition-
opposition doesn't
there
have
is
any
Nothing
annexures.
has been annexed, my lord. No order, the order indicated in the opposition, not a single page has been annexed to the opposition. We could not go through this. What is this? Just my kind see the opposition.
The order, the government order,
Please.
I mean, the ones which have been mentioned in paragraph 3, none of these orders
Yes.
have been annexed.
My lord.
The gradation list, the 100-point roster, nothing has been annexed. So didn't you ask them that you are just giving the reply paragraph number such and such is not to my knowledge and this and that? So it should be, I mean, at least there must be the annexures to endorse what you are mentioning in the paragraphs. What do you mean by next occasion? What will you submit? Who will come to know anything from this opposition, sir? Not a single paragraph can be.
No denial at all.
Next date we fixed on 25th of November. For filing supplementary affidavit by the learned advocate representing respondent number 2, who has not annexed any documents to the affidavit in opposition to substantiate the averments stated therein. Next.
Well, my learned senior friend supposed to me not supply the copy.
Which copy, sir? You have got it? The learned advocate representing the petitioner submitted to have received the certified copy of the writ petition. He is to serve a copy of the same upon the learned advocate representing the respondents. DPL. Next takes for filing affidavit in opposition, sir, you will file.
Mine.
Next date we fix on 24th of November.
Mine. Grateful.
Next.
Then
A copy of the same is to be served upon the learned advocate representing the petitioner in advance for filing affidavit and reply to the same.
grateful.
Next.
I'm for the respondent.
Application touch recorded. Yes, sir. What is this scan 2 of 2025 for? Who has filed this?
Hello. I have had one.
What is it all about?
Yes, village lady, they could not know, they could not ascertain the advocate.
Sorry?
But death of the employee, his family members, they are in a stays in a village in rural. They could
So
not.
this petition was dismissed.
No, petitioner died, my lord. That's a substitution application type.
What is your prayer in the writ petition?
Well, in the writ petition, I prayed for quashing of the dismissal order.
The petitioner has petitioner died, my lord. So he has made an
He's sick.
In the earlier court, I have filed short notes of argument. Hearing was almost concluded, but then unfortunately died the petitioner. This could not be concluded finally. But I filed short notes of argument.
So basically now you feel that you can receive the retirement benefits or whatever.
My lord.
My lord, but at the outset, I must say that on the self-same issue,
Yes, sir.
Lord, one writ petition has been dismissed for default by your lordship on 18th of July on the self-same issue. Yes. In other case. Well, this is the fourth application.
Numbers are same.
Numbers not are same, but first of all, the another learned advocate filed one petition, writ petition on this issue. And this was dismissed for default. Now my learned friend has come out with another writ application on the self-same issue, the quashing of the dismissal order. But
Okay,
two writ petitions are simultaneously.
The learned advocate representing the respondent, Union of India, submitted that a writ petition being number WPA 19643 of 2009 involving the same petitioner claiming similar relief had been dismissed for default on 18/7/2025. The department is to place the case record of WPA 19643 of 2009 along with the case record of the instant writ petition on the next date of hearing. Next date be fixed on 19th of November. Let them place a record, sir. Then it's
And in this matter, can no record of my name, dismiss the matter, my lord.
I'm for the respondents, my lord.
none appear to represent the petitioner. The learned advocate representing the respondent is present. Let the matter be dismissed for non-prosecution. Next.
Building my report in the form of an affidavit.
Report. Wallet. I'm for the petition.
That is a pretty old matter, my lord. Your lordship, on the last occasion, what is fallen from your lordship, that you must explain that so far the notification I have relied upon no date mentioned. That's why your lordship also indicate that in the affidavit you should also give the notification along with the date, and who has recommended the names of the petitioner for consideration also should be considered. It is a pretty old matter. Kindly give me.
Sir, on the last occasion, when today's date was fixed, you must have been asked the time you would say take. So it's nearly a month, sir. The learned advocate representing the petitioner is present. The learned advocate representing the respondent, Coal India Limited, seeks further time to comply with the order dated 7/8/2025 to file the report in the form of an affidavit as stated therein. Next date be fixed on 12th of November as last chance. Next.
I plead to Lordship, my lord. On last occasion, Lordship directed the register administration to ensure the appearance of respondent number 2 and 3, my lord.
My senior, Mr. Subbai, will be appearing for GTA. I will drop a copy of the petition. I kindly, may kindly cover the copy.
Who is representing respondent number 2 and 3? Where is he? Ask him to come. You ask him to come. Yes, ask him to come. Next.
Petition. Lord, the objection to the report, exception to the report. Affirm.
My lord, license advocate Mr. Sumit Paja today morning fallen the stair, so my lord, not this thing.
But pursuant to your lordship's order, Lord, they filed their report. We filed the exception, affirmed. It was not affirmed, Lord, he could not come. That's why it was not affirmed. Now it has been affirmed. We have handed over a copy, Lord. Your lordship will give a date and hear out the matter any day that your lordship please. Because Mr. Paja has fallen from the stairs, he told me. Today itself.
So what was the date of the report filed by them earlier?
Dated 9/12/2024.
The learned advocate representing the petitioner has filed an exception to the report dated 9/12/2024, filed by the learned advocate representing the respondent. State or
No,
WBACDCL?
that will be WBACDCL.
WBACDCL.
Pursuant to your lordship's order dated 3/3/2025.
Be kept on record. The learned advocate representing the WBACDCL as submitted by the learned advocate. Give your name. Being indisposed, could not appear before the court. Next date we fixed on 14th of November for final hearing. Next.
I'm grateful. Grateful. My lord, lordship will take it up at 2 p.m. My lord. Final hearing or
Be in the list. If required, then we'll see.
I'm grateful.
Maybe. None appear to represent either of the parties. Let the matter be dismissed for default. Next.
Results. But I am appearing on behalf of the press in this matter.
I
On the last
for this
occasion, Lord,
respondent.
on 6th of August, when the matter appeared to Lordship directed my learned friend to produce the records of the.
I will produce the
Yes.
record. I have the records.
Yes.
But already written notes has been filed. Pleadings are complete.
Where is the case record?
Yes.
You had to file the case record.
Yes. This is the original copy.
The original case record
Do not get lost. There is no
filed by
problem.
the
I haven't said that, sir.
filed by the learned advocate representing the respondent CISF is to be kept in safe custody by the court clerk attached to this court. Yes, sir. What
Lord,
is your
there might be humble submission. Since the record has been produced by my learned friend, Lord, all the affidavits are complete. But your lordship, under the direction given by your lordship, we have filed the written notes of argument also and the other related papers. Your lordship may kindly fix up a date after vacation. If your lordship wants the matter to be heard, I am prepared. I am prepared to do that.
Next
the-
date
on
we
the-
fixed on 17th of November for final hearing.
Finally, much obliged, lordship.
Only one thing I like to submit before your lordship. On the last occasion, my learned senior friend, my lord, submitted before your lordship that he will be getting some amount of pension, if I remember correctly. My lord, I have the rules also, as because the petitioner did not qualify 10 years of service.
Okay, next, on that day
That
you
day you make your
submit.
submission, elaborate submission, there is no problem. Much obliged, lordship.
Your lordship kindly, my lord, pass the order that the original records, my lord.
That order has already been passed.
Great.
51 minute, I am for the respondents.
Okay, sir.
My lord, on last occasion was your lordship was directed to file the written notes of argument and they will serve me a copy. But my lord, unfortunately, yesterday they have come with the application before me for amendment of the cost title.
Lordship, may I submit?
After of the hearing, man.
Lordship, may I submit? We are being to appear on behalf of the petitioner, Lordship. By the pursuant to your Lordship order, August 13, 2025, it was fixed for filing of the written notes today. In the meantime, what happened? There is a change of brief. We have been engaged newly. I pray before your Lordship for some time for filing the written notes of argument. And in the meantime, what happens? Some of the petitioners are not inclined to proceed with the matter. So in that circumstances, we file a application for the transposition. We file an application for transposition of some petitioners to the 27 number of writ petitioners to the pro forma respondent. That application can 3 we have filed.
My lord, how can it be at this stage, my lord? Earlier, 2 sets of learned advocate has been changed. Now they have come. My lord, that tomorrow another advocate will come, and it is very difficult, my lord.
Just my senior mentioned it in the morning itself. Is that matter? We went to serve it yesterday. He said that we are not receiving this. We'll see in the court.
My lord, at this stage, without leave of your lordship, how they can file this application, my lord, after conclusion of hearing?
Because if we file the written notes right
And
now,
that was the specific direction
faulty
that the learned advocate of the petitioner served the written notes of argument upon me.
No, what is the change circumstances?
They don't want to proceed with the matter because it says taking a longer time. We try to connect with them. They are not responding. 27 number.
So then if that be the case, let them file written instruction.
They are not.
But then you are saying that you have filed an application for transposition.
Transposition. This is the can 3. Lordship, kindly once go to our application.
No, if they are not willing to, how can you make them pro forma respondent? If they are not willing to proceed with the hearing of the writ petition?
Pro forma respondent. We have nothing, no allegations or no, because if our writ petition
I don't think that can be allowed, sir.
If our writ petition proceed, they will also be benefited in
So
that way.
you cannot seek advantage both ways.
No, we are not seeking we have nothing to do with them. That's the thing.
Anyway, sir.
My lord, my only submission is this. My lord, kindly consider that if somebody is not represented by any advocate, then whether they can be transposed as the pro forma respondent, let them, my lord, unrepresented. Who are the representing advocate would be represented by the petitioners who are there, my lord. So what is the necessity to transposing the petitioner from the petitioner to pro forma respondents?
Where have you filed the wakalatnama?
Yes. It's with our can 3. It has been filed. It should be before your lordship.
In any case, this would have been concluded today, if not for this application.
What happened for the filing of the...
Yes, my lord.
Sir, this petition could have been concluded today itself.
Yes. My lord, entire hearing has been my small submission was that on the basis of my affidavit in opposition. That is also very small, my lord. My lord, according to the Railway Board circular, they have applied for promotion. That circular was withdrawn from the cook to my another constable post. So as soon as that was withdrawn, they have no liberty. My lord, in other channel was there for promotion. They have not applied, my lord. My lord, how many days, my lord, kindly see, matter was pending since from 2016. And my lord, how many supplementary affidavit they have used? Now they have come today with another application after conclusion of the hearing. So, my lord, that may be dismissed with the further direction, my lord. They can also, this is their liberty to file the written notes of argument or not, my lord.
Full submission, Lordship, to file grant us some time to file the return of, because we have received the change brief this.
So that could have been your innocuous submission if you want to, irrespective of this scan application being filed.
No, because we can't connect, we can't make any contact with the.
So that doesn't mean that you will transpose them as respondents.
Lordship, in our CAN application,
The learned advocate representing the petitioners has filed an application in CAN 3 of 2025, which inter alia stated that 27 of the writ petitioners could not be
27
of the writ petitioners could not be contacted by the learned advocate representing the petitioners who had been duly engaged on 22nd of August 2025 and sought for transposition of the same as pro forma respondent, which is not allowed. Writ CAN application 3 of is accordingly dismissed.
And in advance copy of the written notes of argument, they will submit.
The learned advocate representing the petitioner is to file the written notes on the next date of hearing. Next date be fixed on 18th of November, sir. On that day, you just give me a short recapitulation and it will be finished off. No.
Your Lordship,
Next.
will your Lordship take the path over, your Lordship?
Wait for some time.
April 2, I am for the respondent, Eastern Court.
Who is for the petitioner? None appear to represent the petitioner. The learned advocate representing the ECL is present. They had to file a substitution application.
Yes, Lordship. Lordship directed to
Okay.
search, Lordship, the department. Department, I do not know what's here, Lordship.
Okay. Let the matter be dismissed for non-prosecution. Next.
For the respondent, my lord, we have to argue today.
For the petitioner, Lordship.
What is it?
Yes, sir.
My lord, this is a case. My lord, may look into the writ petition. The writ petition, copy of the writ petition.
Appear for the petitioner, Lordship.
Page
50, my lord.
50?
50 of the writ petition.
Yes.
This is the fixed deposit one gentleman, Mr. Ovijit Dey, was holding in the branch of Dugapur City Center branch. The date of the maturity, the date of the receipt was 26/7/2014. And maturity is 26/6/2017. And this fixed deposit story is this, that he has entrusted, he was very much known to this person, the petitioner, I mean the delinquent, and he has given the fixed deposit to him. And he has signed at the back of it, he signed. His signature is there, my lord. But all the writings, instructions to park those funds in different 5 accounts written by the accused. So, my lord, this is Ovijit Dey. There is a second back page of it, signature is there. And that is dated 5/12/2014. This instructions was given. Then, my lord, he came, that gentleman, Ovijit Dey, came to the branch and lodged a complaint. That is at page 52. He's saying, the undersigned and account holder of your branch, being account number this, do hereby inform you that 26/7/2014, amount of which 3,000 has been fixed for my said account. Divide this. For encashment, I appeared at your branch today and came to know that misappropriation has been taken place. This complaint was lodged on 2/6/2015.
Yes.
So when the complaint came, immediately bank inquired and he was suspended at page number 53. Didn't get suspended, 53. Then, my lord, he was asked a query, what you have done? He himself framed the question and answered. That is there 54.
Is this that matter where he had transferred the money to his mother's account?
Mother's,
yes,
mother's account and he sent his money to different account, Goldsmith account, then the account of the restaurant where he has to take meals, society, five places he sent him account. And where his mother was a treasurer in one Sanchar Nigam that's there. Now, my lord, 54, 54 is not a disciplinary actions starts on the issuance of charge sheet. But before charge sheet, bank internally makes some inquiry. So when the complaint was lodged, he made some inquiry with the gentleman. He himself framed the question and answered. Let us look into that, what he is admitting there. That is there, page 54A. Himself, he wants to involve other officers of his misdeeds, for his misdeeds. And now, what is the answer, my lord? The page 54A, type page, my lord. 54 is that original page. He himself from the question, he answered it. Now, my lord, paragraph 12. Whether the complaint had approached you on 6/12/2014 for premature payment of his STDR, number this, had proper written application from the depositor, the complaint taken for premature payment of the STDR and appropriation of fund is mandated. Answer. Yes, he approached me. That is that gentleman, that delinquent.
Who has framed this question? Bank?
He himself. Let me go to his affidavit. He himself from the question, he answered it. Bank made some query to him.
So, but sir, then why do you want to indicate these?
Indicate these, he himself admitted here many things.
Okay.
Many things he admitted here.
Yes, it was my handwriting.
My lord?
Page 55. Yes, it was my handwriting.
54, my lord, 54 is, my lord. He approached me. He himself says. He approached
I've seen that, sir.
And then, my lord.
Complainant is well educated.
Then, my lord, 54A. Whether the handwriting in the mandate on the reverse of the STD is yours. Handwriting. Yes, it was my handwriting. As Mr. Ovijit Dey is a valued customer of the city center branch and always had very little time for his inconvenience, the mandates as desired by him was written by me on the anyway. If the handwriting is your handwriting, whether the matter was narrated to the complaint properly and unambiguously, yes, it was properly narrated, he said. He is answering. Then, my lord, question number 16. Was any account opening form for the STDR of 15,000 was taken?
So you come to page 55, 57.
57, my lord?
Yes.
Yes, my lord. 56.
Now, what is that is a crux. There was no intention on my part to act for my personal gain or any attempt to befooling Mr. Sri Ovijit Dey by keeping him.
Keeping his way done.
So he was done. Should say whatever has been done was done by the consent of the complainant.
It is his defense.
Yes.
So therefore, this is the after. So he has done. He has written all the vouchers and he has transferred the account. Where the account is transferred.
Sir, now here it is a very little scope of reappreciating the evidence.
Yes, ma'am.
Now you had given him all the
let me come to the
inquiry report, copy of the charge
First of all, my lord, there is a territory inquiry authority. He has submitted a report of examination, all witness, everything. I gave him to him. the DA gave it to him.
I just want to ask you whether the compliance with regard to the processes of the disciplinary proceedings.
All procedural aspects.
He has received the copy. He participated in the proceedings. There was no violation of principle of natural justice.
That he admitted himself. Let me come to the affidavit, my lord. Our affidavit. What he admitted. He himself said, no natural justice was not violated.
Where? Which page?
I'm coming to. My lord may come to page, our affidavit, page 73. TSE, charge seated employee and 2 EO. I confirm that I was present in the inquiry all through, and every opportunity was given to me to defend my case.
Sir? Which page?
At page 73.
Huh?
73.
73.
About affidavit.
Yes.
73. CAC, charge seated employee, 2 EO, inquiry officer. I confirm that I was present in the inquiry. Last paragraph, last but one paragraph. I was present in the inquiry all through, and every opportunity has been given to me to defend my case. And natural justice has been provided to me. He himself is admitting before the inquiry authority.
Okay.
Thereafter, inquiry authority submitted a report stating all the charges are proved. Thereafter, statutory authority appeal is there. Very senior officer of the bank. They are not harboring any animosity against him. Possibly they don't know him also. And they have also confirmed it by detailed examinations and his defense, etc. Then he filed appeal. Then he filed review. Then appeal. Then appeal was ordered also confirmed. Now, my lord, so this is the position. Now, what happened? The vouchers, he is making a story, because in the bank, when you go, if you give a check, my lord, somebody passes the check in the counter. There is another officer, he is a checker, another officer is a maker. He is not looking at the particular check. He is looking at hundreds of checks. So checker, he is involving the checker also, why he passed. Checker also punished, but not to such an extent. But checker has given.
He was removed.
No, he was not removed. Because checker was there, he says that.
No, petitioner was removed. Petitioner was removed.
Yes. He's not removed. Now he has passed, all the counters, checkers are coming. Checkers are checking everything, all these, and he puts in the computer to look into that this has been paid. So he has given explanation in the affidavit itself, the witness, that I am an officer looking after so many things, and I have a deposed faith on my employee, I'm a staff. And he has, in the meantime, and he has no personal gain. He has no connected with these transactions. But this gentleman was connected with the transactions. And most importantly, my lord,
okay, sir.
I am coming to that. When it was detected, my lord, the day, that is the most important. When the detected particular date, on that date, he plowed back the money from these 2 persons. And entire money was paid back.
Filed the written notes I've seen.
Two lines. He plowed back the entire money from 2 accounts. His mother was a treasurer there, and from there he got the check, 2,17,000. And when he was asked, then he said, I've given a loan. If it is a loan, the payment of interest is 87%. So it was not there. So all these things in the evidence it will come by. So then at the time of plowing back the amount, all the vouchers he prepared. But very interestingly, he did not sign anything. His ID number was not used. It was used by some other officers. He asked them to pass it, because every bank, everything goes on faith. Well, reposed faith on that. They reposed faith on this colleague. And he made these things. And he is personally interested in this proof. He made it, but these persons were not personally interested. But still then, they were downgraded in the scale, etc. That have enclosed their punishment in my affidavit in opposition. I have enclosed it. But he was removed. This sort of person, dishonest person, cannot be retained in the bank. Because I am to run the bank of 2 lakh employees. Public money, I have to deal with it. So this is my admission. As regards the, I have submitted.
Did you file your written notes? No.
Notes have been filed, your lordship. I have been given
one supplementary 3 judgments, my lord. I have submitted. That my lord is fully aware of it. The other case I was argued. This is one is Gunasekaran. What are the things the appeal court can look into that? 2015, my lord. Then, my lord, another is Bela Bakshi. Loss is not, because he is saying bank did not loss, because ultimately money was plowed back from those persons and paid back. So bank did not, monetary loss is not there, but reputation loss is there. Reputation was lost, was there. Then, my lord, the criminal case, everything is to prove. But in the domestic inquiry, my lord, preponderance of probability is looked into. That judgment I also gave. So in the context, this sort of employee cannot be retained in the bank, my lord. So therefore, dismissal order was rightly issued.
So you mentioned those judgments in
Yes,
your.
I have enclosed this. Today I have enclosed those judgments also. A supplementary note I have given. Then later.
Your Lordship, I have just received a copy of this supplementary notes.
Only
Just the
judgment.
judgments are given. Even if I have to like deal with it with any other judgment, can I like place it before your Lordship on another date? If maybe a week's time.
Heard
maybe
the
for that.
submission of learned advocate representing the respondent bank. Supplementary notes of argument filed on behalf of the respondent bank be kept on record. Next date be fixed on 19th of November for final hearing. But they want to distinguish probably the judgments. Let them do it once. Next. And as last chance.
Yes, your Lordship. I just received the judgments. Your Lordship.
Next.
For the petitioner, my lord, I'm praying for only short passover, my lord.
My lord, I am for the respondents.
আগে যে পাসওয়ার্ড গুলো ছিল ওটা একবার দেখে আগের পাসওয়ার্ড whoever it is to come fast.
I had informed the advocate on record. His junior was right here. She's on the way of the Lordship, he's the clerk for
The
the.
learned advocate representing the petitioner
She's here.
is
I appear for the petitioner. For the responding, Your Lordship. I was.
Are you the advocate on record?
Lordship, my senior is there.
Where's your senior?
Lordship, he's in court 39. Lordship, my matter is. Lordship, he's he's on his legs, Your Lordship.
You were there when the matter was called up
Yes,
in the morning.
I'm there.
I mean,
Lordship.
later, earlier.
Yes, I was.
So why didn't you submit?
Lordship, I was not there that time. I was waiting for the passover matter to be called. For the long time, I was waiting, Your Lordship.
Go to paragraph 3, 2 and 3. Isn't it contradictory?
It is, but we
When
don't
you
have any knowledge.
stories,
No, your lordship.
cook it with some substance.
Is over here. We did not have any knowledge about it. The erstwhile lawyer didn't even tell the client. So the matter has come up to us, and since then we have been. This is the only plea that we have been able to take because this is entirely honest, your lordship. The client also had no idea about it, and we have been appointed subsequently.
The learned advocate representing the petitioner submitted to have filed an application being cancelled of 2025 inter alia, praying for recalling of the order dated 3/10/2024 passed in 502 of 2011.
522, your lordship. That might be.
What have you written in the what is mentioned in the prayer portion?
Might be a typing mistake, your lordship. Clerical error. 522. Your lordship, everywhere else has been given 522, your lordship. Even the application as well. As well as in the cause title, it's 522.
What is your name?
Parandaga.
Where's your wakalatnama?
Lordship has been given with the can of 2, the previous can that was filed. A can that was filed. Lordship, I will tell you what happened. The order was for the
I don't have time to listen to your story. You don't have that, I mean, that kind of 522 of 2011. Passed by the coordinate bench of this court, dismissing the instant writ petition for default. So considering the averments therein that the order dated such and such be recalled, the petition be restored to its original file and number. Was there any direction to file affidavit in opposition earlier? You don't know anything.
Direction.
What is the prayer?
Prayers for restoration, your lordship, this application.
What is the prayer in the writ petition?
The termination of the petitioner was illegal, so we are for the reappointment of the petitioner and
the learned advocate representing the respondent is to file the affidavit in opposition, serving a copy of the same upon the learned advocate representing the petitioner in advance. Next date we fixed on 11th of November for filing affidavit in opposition.
Well, it's my writ petition, Milord. Your lordship had called for the advocate on record for the provisional fund. Milord, may I indicate, Milord?
The heard the submission of learned advocate representing the petitioner. The learned advocate representing the respondent number 1 to 3 did not appear. We register administration. Give you notice.
Milord, may I just
For,
seek one indulgence, Milord?
Intimating the next date of hearing. Next date we fixed on 12th of November.
Milords, may I just seek one indulgence, Milords? Milords, I'm just seeking to file a supplementary affidavit, Milords, just to bring on record, Milords, my registration under the West Bengal Societies Registration Act.
Weren't you registered at the time of?
Yes, Milords, I was registered, Milords. It is appearing, Milords, but we have not annexed the document, Milords. Just leave to file a supplement, one pager, Milords.
The learned advocate representing the petitioner seeks to file a supplementary affidavit in order to place before the court the certificate of registration of
Under
the,
West Bengal Society Registration
the
Act.
petitioner under
West Bengal Societies Registration Act, Milords.
West Bengal Societies Registration Act, and the same is allowed. Next.
1961, Milords, the year. Deeply obliged.
41. Please,
Lordship, I'm appearing for respondent number 2 and 3.
You are appearing, you must have received the notice and thereafter appeared.
No, Your Lordship.
Then?
It was appearing, and then I was told that this matter is appearing. Kindly.
You are not engaged in this matter.
Officially, I'm not, Your Lordship.
Officially or not?
Officially, I'm not, but I am the advocate for the GTA. Usually, I appear, Your Lordship. I'm not the retainer, but I appear for GTA.
A notice was served upon the GTI.
Yes,
whatever you are. GTA, Gorkhaland Territorial Administration.
That's right, Lordship.
And they have not engaged you.
But they have told me to appear now, Your Lordship. Let them serve a copy to me, Lordship. I'll come back with the instructions. What is there in the matter?
My lord, I am submitting the supplementary affidavit, my lord. Lordship is directed allow us to file on 5/11/2024, my lord. My lord, kindly come to the my lord, order of the 5/11/2024, my lord.
Okay. To get you on board is a Herculean task nowadays.
Affidavit of service also as per lordship.
Supplementary affidavit filed on behalf of the petitioner be kept on record. Affidavit of service filed by the learned advocate representing the petitioner be
My
kept on record. Learned advocate such and such submitted to have been instructed by the respondent number 2 and 3 to appear on their behalf. However, he further submitted to have not been officially.
No, Lordship, officially means not officially. They
officially engaged.
My lord.
The learned advocate is to seek official engagement to represent the respondent number 2 and 3 prior to the next state of hearing. Affidavit in opposition, if any, to be filed on 13th of November. A copy of the petition is to be served. Within how many days can you get the official engagement? Can you within
by next week, by this weekend, Your Lordship, I think. By Thursday. Or Monday, by Monday, Your Lordship.
Let the matter be fixed under the heading to be mentioned on 8th of September. By 8th of September, you obtain the official engagement.
My lord, kindly come to my lord, order dated 14/1/2025, my lord, as well as he is appearing on respondent number 2 and 3, as well as my lord 6, 7 and 8, my lord, as per lordship direction, my lord, on CAN application. I have filed on CAN application for addition of.
He had appeared earlier.
No. I have served, my lord, and party has been added as 6, 7 and 8 as well.
Lordship, let him give me a notice of the thing, Lordship. A copy of the application, Lordship, at least.
You can serve him. And in the meantime, you seek your official.
My lord, he is appearing as on behalf of respondent number 2 and 3, as well as 6, 7
Next.
and 8.
শুধু ওনার নামটা দেবে আর
Sir, Anindya Haldar is appearing, my lord. Today is the date. File the written notes of argument, my lord.
who are you, sir? Are you the advocate on record?
Yes, my lord. I'm.
Chanchal. Are you ready?
Yes, yes.
Where's your written notes?
So that is not ready, but I have to make some verbal arguments because on the last occasion they have relied on one judgment of the Honorable Guwahati High Court, which I have to distinguish.
Okay. Written notes filed by the learned advocate representing the petitioner be kept on record. Now tell me, what is it?
Now, if my lord kindly comes to that judgment relied on by them on the last occasion,
Yes.
kindly come to paragraph 6 and 7. The facts are absolutely dissimilar. In this case, in the cited case, paragraph 6, if my lord kindly comes to, of the judgment cited by the passed by Honorable Guwahati High Court,
Back page?
paragraph 6 and 7, I think. একবার কপিটা দাও না, কপিটা দাও। না, ওই judgment-এর কপিটা দাও।
Yes.
Yes, paragraph 6. Kindly, may I read it? From the findings of the inquiry report, it is clear that the victim died due to firing and sustained bullet injuries in the chest. And it is also apparent that the victim was not in close proximity, but at a distance. 7. Therefore, from the inquiry report, it remains no doubt that the cause of death was due to the firing by the BSF personnel from a distant. Hence, the respondent is liable to pay compensation to the petitioner for losing his son. Here, the case is absolutely different. In this cited case, there was a deliberate firing. It cannot be said to be an accidental fire. The question of right of exercise of self-defense does not arise at all in the cited case. But in this instant case, the BSF personnel while on duty on the international border was attacked with sharp weapon. And while there was a physical tussle, the gun was loaded and it went. Gun went through. So there was a stark difference between the cited case and the instant case before your lordship. So this judgment to that extent is not applicable. That is what I want to say. Because in this cited case, there was a deliberate firing. It cannot be said to be an accidental fire. But here, if my lord kindly comes to our affidavit in opposition, where we have stated the entire fact as well as annex the FIR, my lord will find what has actually happened on that day. Paragraph page 4 onwards, we have stated the entire fact.
Yes.
May I place Roman paragraph 2, page 5 of my affidavit in opposition.
Which page?
Page 5 of my affidavit in opposition.
Yes.
Roman 2. On 20th July, may I read it, well? On 20th July 2006, at about 1200 hours, when Constable Vishwaprakash was proceeding for the OP duty, he had an altercation with a civilian, namely such and such, husband of Najima Bewa, the petitioner, aged such and such, residing at such and such, as the civilian was blocking the road at a distance about 100 yards from border outpost Kishtopur. However, with intervention of other personnel of OPD party, the altercation was stopped. At about 12:10 hours, when Constable Vishwaprakash reached his duty point, which was outside village Indra colony, and at a distance about 50 yards from the house of the civilian petitioner's husband, while Constable Vishwaprakash was on OP duty, the petitioner's husband attacked on her with lathi. However, a lady who was having a da in her hand tried to stop him, but other 3-4 persons who were also carrying da were instigating petitioner's husband to attack. The petitioner's husband, Jabir Rahman, hit Constable Vishwaprakash on backside of his left shoulder with a blow of lathi. In the meantime, Jabir Rahman also snatched the da from the lady and attacked Constable Vishwaprakash. Thereafter, Constable Vishwaprakash fired one round from his weapon, Incest rifle, butt number 432, body number such and such, in air. To scare him away, Jabir Rahman tried to snatch the rifle of Constable Vishwaprakash and he grabbed the rifle. As a result, the scuffle took place between them. During the course of scuffle, two more rounds were fired accidentally from the rifle of Constable Vishwaprakash and one of the bullet hit upon Jabir Rahman. This is the fact. Thereafter, the body was taken away by the local civilians. We lodged a FIR, police recovered the body, we initiated a GSFC proceeding, and by virtue of Section 80 of the Indian Penal Code, the the General Security Force Code acquitted the constable. There are 2 points. One is obviously the delay point is there because the incident is of 2006 and the writ petition is of 2017 after 11 years. Secondly, my lord, neither that person, that Jabir Rahman, nor the petitioner was a member of the force. So they cannot challenge the GSFC proceeding. Neither.
Challenging that.
No, you are paying, yes, that is mean unless we are at guilt, why shall we pay compensation? Unless we are at guilt, why shall we pay compensation?
This Milord Meghalaya High Court judgment Milord fits my case. Milord, here also Milord, what happened Milord? Here Milord, their contention is that we have attacked the BSF personnel and they have assaulted us, Milord, fired from their arms, Milord, in which resulted in the death of the petitioner's husband. Now Milord, what happened? Same was the case here. Milord, the BSF personnel Milord alleged that there were certain trafficking going on between the borders of Myanmar, Milord, there, where Milord, they have assaulted Milord the petition, that person, where the person died, and Milord, there was the inquiry report, where inquiry report reveals that by the BSF personnel.
At a distance, firing was at a distance in this case. What? No, it is written there, not in proximity, but at a distance. There was a deliberate firing in the cited case, but here there was an accidental firing. There is absolutely different case. In this case, cited case, the BSF personnel deliberately fired at the victim.
And Milord, 3 rounds of bullet in self-defense, and that too Milord in the chest, not in the lower portion of the body. Milord, this, if this be allowed, Milord, the self-defense, Milord, cannot be, Milord, the personnel cannot, Milord, hit, Milord, the chest, Milord, direct.
No, the gun was loaded and the gun went off. That was the case, but the GSFC came to a finding that the gun went off due to the scuffle of the petitioner along with the BSF personnel. It was not a deliberate firing by the BSF personnel.
It was not the case of the BSF that I was trying to cross the border, or I was.
No, the petitioner's husband attacked the BSF personnel.
And the BSF personnel was in an intoxicated condition when this thing happened.
These are afterthoughts.
These are afterthoughts.
I made a copy there.
You will file written notes?
Yes.
Heard the submission of the learned advocates representing the respective parties, the learned advocate representing the respondent, BSF.
BSF, all the respondents.
Respondent intends to file the written notes. Next date we fixed on 17th of November for filing.
There was a direction. They have not complied with it.
Next, if I go on finding such directions to have not been complied by you also. So both of you are on the same platform.
I'm grateful, man. I'm extremely grateful.
My lord, this matter, my lord, Mr. Nilod Paul Chatterjee is on behalf of the state. He's engaging
He has
at
to
another.
file the affidavit in opposition. There was a direction to file affidavit in opposition today.
My lord, I am not his chamber junior. I have been just requested by his junior to take time. That is why I'm just praying
You
for.
ask him to come. There is no
Kindly pass
question
over
of-
the matter. He will come. Grateful.
Next.
But 59, my lord, I am appearing on behalf of Union of India.
My lord, I am appearing for this
Applicant. My lord, yesterday I have received the brief. My lord, I have to take instruction in this matter.
Whenever the matter is fixed, just yesterday,
My lord, your lordship,
instruction is received.
kindly see. On the last occasion, my lord, none appeared on behalf of the Union of India.
Union of India will not be represented, state will not be represented, then again administrative notice has to be sent, then only you will people. Yes, what is it?
My lord, petitioner before your lordship, my lord, he was an employee of railways. He was posted at Adra. He was in RPF. My lord will
You have
still.
come for today, sir. On the next occasion, will you be there?
Yes, yes.
You will be there?
Yes. I have been engaged in this matter.
Application of mind.
Because generally today you will come, then on the
No,
next
no, no, no,
date
no.
you
No,
won't.
lordship. We too have been engaged very recently. Yesterday we have received the brief.
Tell me.
My lord,
Forgotten? Matter is of
No, no, no.
2018.
it is the RPF authority comes under the my lord, Southeastern Railway. RPF authority. Well, the petitioner before your lordship was, my lord, happened to be the head constable. And my lord, during the service, he was, my lord, suffering from some mental diseases, and thereafter, my lord, treated at, my lord, Kake at Ranchi in the psychiatric hospital at Ranchi. Now, my lord, your lordship will find, my lord, the prayer.
You have a copy of the petition?
Yes, yes. We have received.
There was a direction to file affidavit in opposition in the year 2018, 27/6/2018.
Yesterday we have been engaged. Lordship, kindly give extend some time so that we can file, my lord.
Let him file the affidavit in opposition.
Well, they have submitted opposition long back. Reply also ready. They don't have, my lord.
That copy we don't have.
Opposition and
এটা
reply.
রেকর্ডে আছে কারণ এই এর ডিপার্টমেন্টের নোটিং যে ফাইল করা নেই যদি
আমাদেরকে একটা কপি দিয়ে দিও তো আমরা
it's not on record. So you give him a copy of the opposition so that he can reaffirm and file. If you have the copy of the opposition.
ও তো আমি ওকে জানি ঠিক আছে
The learned advocate representing the petitioner submitted to have received a copy of the affidavit in opposition on behalf of the respondent, railway authorities. However, the said copy of affidavit of in opposition has not been filed in the court. The learned advocate representing the respondent railways is to reaffirm the copy of the affidavit in opposition so served upon the learned advocate
everything is ready.
representing the
Kindly fix for next week so that
no
to be filed in the court on the next date of hearing. How long will you take to get it reaffirmed?
At least 2 weeks or 3 weeks time, lordship.
3 weeks
Next-
vacation will come.
Next date be fixed on 18th of September for filing the affidavit in opposition.
After vacation, your lordship.
18th of September.
Malad, can Malad fix it till 16th? 16th, Malad, kindly.
No, it will be
Because
difficult
that
for
is
us, my lord.
after Malad.
Railways, they have their office here in Kolkata.
Yes.
Then you can get somebody.
My lord, they will be coming from Adra.
No, South is
Garden Reach is the headquarter. Officers will come from Adra. We have
16th, Malad, prior to Vishwakarma Puja.
No.
16th, it can be
no.
possible.
It will be
Rather,
difficult, my
7th,
lord.
after 7th.
It will be difficult if your lordship fixed prior to my lord.
No,
They
they
will
can
reaffirm
come.
only.
They will come and reaffirm and go. 16th of September then. You file the affidavit in opposition, they will file the reply, and then after vacation, the date will be fixed for hearing. So you need not worry that way. Next.
And for the petitioner,
Yes, sir.
Millard, last time,
Your Lordship, Mr. Uttam Kumar Mondal is appearing for respondent number 7, Your Lordship. He's on legs, Your Lordship. I'm praying for
Yes, sir.
the question is the last time Your Lordship directed them just to amend. They are telling National Thermal Power Corporation is not there, NTPC. And Your Lordship directed the department to make the amendments. Second is this copy of the writ petition. I have already submitted on the same date.
Okay. Tell me what is the issue?
Issue is this. I have already submitted the written notes of argument. I think that was over.
Just tell me a bit so that I can recapitulate.
The question is this: the petitioner was employed in National Thermal Power Corporations, and after taking permission from them, he applied to he applied for IBP, oil company, IBP. And IBP, and after obtaining no objection, they joined this. Issue is simple, and thereafter IBP was merged with IOL, Indian Oil Corporations. Now the VRS scheme was introduced by the IOC. I applied for. Question is this: as per the government ministry circular, all the service periods of all the undertaking, government undertaking concerned, to be taken together. If there is a continuity of this. I have established that there was a continuity. In that, what they have done, they have not given me the gratuity for the service period I rendered at National Thermal Power Corporations. The condition was that, as per the government circular, that the leave encashment and PF should be transferred to the new company. There was no leave accrued, so I have not transferred, but the PF contribution was transferred, and that is on record. Kindly see page 30, 54. I have given page 30 and 54.
You are representing whom? So the earlier one.
This one of 4 and 5. No. The earlier one is the NTPC. From NTPC, he came to us.
So you have done your job.
Whatever I received from NTPC,
Yes,
I have
yes,
delivered.
yes. And they have transferred.
So what is the
Kindly
amount
see
which
page 30.
remains to be transferred?
Huh?
What is the amount which remains to be transferred?
Question is the service periods, 5 years service to be accounted, and thereafter I'll get the VRS incentives and the gratuity. And National Thermal Power has done the job. With page 30, they have transferred the CPF calculation to IBP company.
So who is not giving you?
IOL.
Why?
IOL says.
According to you, why they are not giving you?
Yes.
Page 30 is the
transfer. National Thermal Power has rightly transferred the accumulation of PF.
Now they are saying whatever in the National Thermal Power has transferred, they have given it to you.
No, that is a PF. That is PF is to given. But as far as the gratuity is concerned, length of service, that length of service has not taken into consideration. There's 5 years period. Now, in their revenue reply, they have admitted the fact, the policies they have admitted. But they are telling that we have not received anything as a gratuity amount. Gratuity amount is not transferred. Gratuity is the gratuity is paid after the retirement, after this service ended by VRS here. That period of 5 years period I have lost. And I have also annexed one thing is this, kindly see page 54. The government has given me an RTI reply. Item 3, question number 3.
What is the scheme? 55-2000? Where is the scheme?
The scheme is here a scheme that they have introduced, and they can introduce only as per the ministry guidelines.
Okay, কে আছে এখানে?
Madam, may I written notes of argument I have submitted and also
I
judgment
picked it
of
for orders
Misappropriation.
for the submission of learned advocates presenting the petitioner as well as respondent number 2,
4 and 5.
4 and 5. Anything else you have to say?
Fine for the respondent.
You can.
Lordship,
But
I for the respondent.
that portion, it has to be continued. Page 54 that he has shown. So that speaks for everything, sir. Isn't it?
And National Transport has got nothing to do.
No, next date we fixed on 20. কটা orders এ fix করলাম না? 20 November for orders.
20th November. Meanwhile, if I can get any judgment, I may be allowed to submit it to the office.
Next.
Lordship, I am for the respondent number 7 NTPC. Let my appearance be marked, Your Lordship.
You are the advocate on record?
No, Your Lordship, the junior of the advocate on record we have already.
So let the advocate on record come, then only his name will be there. Next. Four.
My lord, আমি শুভদীপ ভট্টাচার্য। আমার উকিল আমি অনেকদিন ধরে ওনার সাথে যোগাযোগ করতে চাইছি, কিন্তু উনি আমার সাথে কোনো রকম কোনো যোগাযোগ করছে না। ফোন করলে উনি বারবার আমাকে বলছে আই উইল কল ব্যাক ইউ লেটার। তো আমি আজকে নিজে আপনাকে অনুরোধ করতে এসেছি যে আমার একটা উকিল ঠিক করতে হবে, তার জন্য কিছু সময় চাই। আর আমার লয়ারের কাছ থেকে আমি এনওসিটা নিয়েছি।
Have you seen the NOC? Just see the NOC.
No objection, Lordship, the date is not given.
What is the name of the advocate written there?
জয়ন্ত মিত্রম।
The petitioner appeared in person and sought time to get himself represented to a learned advocate, having received NOC from the erstwhile advocate on record. The learned advocate representing the Respondent Union of India is present. Next date be fixed on 12th of November as last chance. সেই দিনের আগে আপনি কোনো একজন উকিল বাবু কে নিজের জন্য অ্যাপয়েন্ট করে নেবেন। নেক্সট।
I am for the respondent.
The petitioner prayer is compassionate appointment, my lord. The petition is a married daughter. On this ground, my lord, my application is rejected. But the order impugned is in page number 69. Initially, an application for compassionate appointment was made. Subsequently, an application was filed for not consideration of my prayer before this Honorable High Court. Honorable High Court directed to consider, my lord. In consideration, this order was passed. May I lead for my lord? Justice Ravi Kishan Kapoor directed the grievance of the petition is that the petition is a married daughter of one Niranjan Bauri, who died on 15th October 2014 in harness, and she is entitled to get compassionate appointment. The petitioner relies upon a special bench judgment of the Honorable High Court in Putul Rovidas versus Eastern Coalfield Limited, dated such and such. The respondent relies the decision of the case in Eastern Coalfield versus Kumari Kiran Singh on 14th December 2018, wherein the Honorable Division Bench of this court has held that a married daughter is not entitled as a matter of right to the compassionate appointment. He further submits that the petitioner's mother is entitled to compensation under the National Coal Wage Agreement in lieu of the compassionate appointment. In view of the aforesaid, both the parties agree that the matter remanded to the General Manager, Eastern Coalfield Limited. Respondent number 3 is directed whether the petition is entitled to any compensation or monetary benefit. In accordance with law, it is needless to mention that the respondent number 3 will conduct the entire exercise within 6 weeks. But in the meantime, my lord, a new judgment has come.
You come to page 71, last paragraph.
71. Yes. Finding. On going through the case record, the statements recorded by Pushpo Bauri, the wife of Niranjan Bauri, and Srimati Bulu Bauri, there is the petitioner hearing. In the course of hearing held on 21st December 2019, it is evident that Pushpo Bauri is more than 45 years as on the date of death of Niranjan Bauri, which make her eligible only for MMCC, although Srimati Pushpo Bauri denied for accepting MMCC. It is evident that Bulu Bauri had already crossed the age of 35 years at the time of the death of her father, Niranjan Bauri. Hence, she is not entitled to be considered for compassionate appointment on the death of her father, Niranjan Bauri. Moreover, there is no specific provision for giving compassionate appointment or any compensation or monetary benefit to the married daughter. The claim by Bulu Bauri for service of the compassionate appointment grounds cannot be allowed. But in the meantime, a new judgment has come that married daughter is also entitled to get a compassionate appointment.
But is there any age bar?
Age bar, the scheme framed by them, they will answer. The scheme, according to the scheme, the compassionate appointment can be granted. The scheme, they have.
No, first of all, they said Bulu Bauri had already crossed the age bar of 35
yes,
years.
Yes.
So,
that is the observation.
irrespectively, whether married or unmarried, so does the scheme provide for a specific age?
May I read the scheme? What is this?
Which page?
CW6.
Page?
Right, I'm coming.
I also not annexed lot.
You have not annexed.
Where is the scheme?
My alert. When a scheme is not annexed,
Then
it is
issue of married, unmarried
yes
is settled, but age.
No, Lordship, married daughter, unmarried daughter come later, first come wife. The first right of the wife, not in any judgment.
So in any case, sir, the scheme needs to be gone through.
Yes, Lordship.
The scheme is not there.
Lordship,
a scheme
certainly.
is not there.
The heard the submission of learned advocate representing the petitioner, who is to place the scheme of which year?
NCW 6 is six is old, Lordship, but in later on after 5 years.
Mentioning the requirements.
National Coal Wage Agreement 6.
Eligibility for appointment on the for appointment for compassionate appointment. The learned advocate representing the respondent is present. Next date we fixed on 24th of November.
Good.
Next.
Nine and 7.
The last occasion, we had filed a supplementary affidavit to which they had taken time to file a reply. They were supposed to file their reply by the 20th of August. They had not done it. Just yesterday, they've caused the service of a reply of our opposition upon me, Your Lordship. They've relied on certain documents, some of them which they have pleaded, but not annexed. Your Lordship, my humble request will be to
Where is
close this
the affidavit in opposition, sir?
My lord, this is the affidavit of opposition, my lord. Learned advocate Mr. Gaurav Das is appearing for the state, my lord. He is very unwell, my lord. He is unable to come to court.
Your Lordship, on the 21st, we had already written to them that the opportunity was last on 20th August. After that,
Affidavit
yesterday
in opposition filed by the file on behalf of the state respondent, we kept on record.
Lordship will give me a week's reply. I'll come back before the puja vacation because this has been going on for some time. Kindly, Your Lordship.
Affidavit in reply to be filed by the learned advocate representing the petitioners on 23rd of September.
I'll come back within a week because, Your Lordship, this is subject to if it's Your Lordship's business permit. So that Your Lordship had already expressed her mind that Your Lordship is going to rule. Your Lordship is going to pronounce on that when both the applications are heard out in totality.
Next.
Lordship will kindly. Will it be Your Lordship's pleasure to allow me to come back within a week, Your Lordship? Because this is going on for the last 5 years, Your Lordship. That's for it.
Let them come back 1 week and you will not seek a day's
No, Your Lordship.
time.
I won't.
Next date be fixed on 9th of September for filing affidavit in reply.
Thank you. Grateful to you.
71.
Well, in this matter, my lord, I start my submission by apologizing to this honorable court for the reason, my lord, I missed my brief today. And as a consequence, I'm incapacitated to make any submissions.
No, yes, on the last occasion you appeared online and you said
I
you
made
were.
my submissions, my lord, and thereafter not completed because of that online. Unfortunately, my lord, it was after coming to court that I realized that I read it yesterday, but somehow, my lord, I completely.
Counsel. You wanted to conclude.
I will conclude. I just require to some queries and that's it.
So then after vacation, prior to vacation, there is no time. On the prayer of learned advocate representing the petitioner, let the matter be fixed on 24th of November. Next.
77.
Your Lordship, Mr. Arjun Shamanto is appearing for the state. He is engaged in courtroom number 11. I'm praying for a short passover, Your Lordship.
Yes. Sir, will you please use the mic? Sir, please, will you please use the mic?
Sorry, madam. My lord, the group D post, my lord, under the district judge Bankura, at the post of his father expired, and my lord, original documents, my lord, at that time when he filed application, my lord, his mother filed application, my lord, is a layman, my lord, village people, my lord, he could not file the original documents. But my lord, this is the original documents, my lord, I'm saying.
Sir, how can you just like that file the original documents, sir? Was there any direction?
Because my lord rejected my candidature, my lord, this is my lord, the genuine, the certificate is not genuine. My lord, can you see? But the order is, can you see the order?
Which date?
Can you see? The last portion, my lord, can you see? My lord, the documents, my lord, page 25.
Page
25.
25.
25, my lord. I'm sorry, my lord. After verification, I have got the requisite qualification. Plus, I passed class 8 from beginning, my lord, different school I have read, but lastly, my lord, I class 8. The original documents is here, my lord. But they are saying the documents is not, my lord, genuine one. Absolutely, my lord, you are can see. Also, my lord, Santal, my lord, STD candidate. Plus, my lord, certificate is there, my lord.
So you file those documents in the form through an affidavit.
My
Okay, Chanchan.
Reply, my lord, you will kindly see the reply.
I mean,
Reply, my lord, you will kindly see. I have submitted all the documents.
who is representing the district judge?
Right, my lord.
Acha, chalo. The
Reply, my lord.
learned advocate representing
You will also kindly see the last
petitioner
order.
has
Your lordship,
filed
kindly
the
last order.
affidavit
You
in
will kindly
reply.
see your lordship last order.
The affidavit in opposition filed by the
Fine.
filed on behalf of the respondent number 4. The learned advocate representing the petitioner is to file certain documents referred to the court today in the form of an through a supplementary affidavit. Full stop. The Registrar Administration LOM
Father expired.
is to serve notice upon the respondent number 2 and 3.
They have also give opposition, my lord, they have given opposition, a bit opposition. I reply
Who were not represented today before the court to get themselves represented on the next date of hearing. Next date we fixed on 19th of November.
Your Lordship, Mr. Arjun Samanta was appearing for the state, Your Lordship. He was present all morning, Your Lordship. He had a hearing matter in court 11, that's why he had to leave, Your Lordship.
Next.
3 and 4 August, your lordship. The last one, 3 and 4 times matter has been adjourned, may not have come before.
83. Not I am for the
For hearing.
19th of November.
And it will appear for hearing, my lord.
Yes. Yes.
85, I am happy to offer the state respondent.
Sir, on the last date, on 18th of June, also on his ground, you had sought for time.
Lordship, later I filed the affidavit in opposition, which is affirmed on the 1st October of 2021.
You have not, who are you representing?
I am for the state, Lordship.
You did not appear on the earlier occasion?
Yes, Lordship. I appear and I
85.
mean 85. I am in 85.
83.
Same matter too.
Same.
Ashun, you are the advocate on record?
Yes.
On the prayer of the learned advocate representing the petitioner, let the matter be adjourned for the day. It 80
83.
And you are filing affidavit in opposition in
85. Last year. Analogous with last year.
80.
84. I am for the petitioner. Mr. Counsel. 85.
85, I am happy.
So then 84 and 85, 83, 84 and 85 are the same.
Same.
And what about 84?
Yes, 84 also.
84. What is in filing?
I am in 85. Lordship.
Then what about 84?
84, another respondent is there.
Mr. Hanson, here on some of the state matters, not 85, opposition matter.
You are representing the state in 85. Learned advocate, 85 eligment. The learned advocate representing the state respondent has filed the affidavit in opposition. Let the same be kept on record. Let the matter be adjourned for the day. 3 matters.
Yes.
Tomorrow it will appear. Next.
87, I am for the petitioner. This is a hearing of writ petition. You also kindly take it after. Let Mr. Partho.
So let them file their opposition. If they did they file it earlier?
Petition reply ready.
Yes, ready.
Ready.
Original file.
Because I find that they had to be called on. On the earlier occasion, they did not appear. So administrative notice was sent. That is why they have come.
I'm newly engaged in this matter now.
They have been newly engaged. So who was the earlier advocate?
Partha Ghosh.
Partha Ghosh.
So you have the copy of the petition.
Yes, madam, I have the copy.
You have everything.
Yes, madam.
Affidavit.
Madam, Mr. Ghosh is, madam, this was brief is, madam, he has given the junior.
Ashun. Sir, is it you have come against termination? Termination of service?
No, everything is completed.
No.
What is the prayer in the writ petition? Have you come up against termination of service?
No, not termination, but punishment was awarded. I have challenged that.
CISF or BSF?
Railway Protection Force.
Okay. On the prayer of learned advocate representing the petitioner, let the matter be fixed on 24th of November
24th of November.
For final hearing.
My lord.
Can I, your lordship? I am for the respondents, this matter. The last
Lordship
occasion-
will remember this matter.
Yes.
The Lordships will remember this matter is regarding the employment wherein the petitioner was given a interdepartmental promotion. Thereafter, the results were changed because the number of candidates to be recruited in each category was wrongly calculated. So they rectified the calculation, and I was again demoted back to the previous designation, your lordship. Now, all I am seeking in this writ petition is that I ought to have been promoted to that category. There are only two grounds which I need to show your lordship for in order to for your lordship to entertain my claim. One, in a previous writ petition, I have after the departmental hearing, I have gone before the CAT, and thereafter I had approached the Honorable High Court. In that order, your lordship, by the Honorable Division Bench of this Honorable Court, had directed that if there was vacancy at that relevant point of time where the petitioner could have been recruited, then the petitioner is entitled to get that promotion. Held that. The Honorable Division Bench of this Honorable Court. So that part is over. I'll come to the documents, your lordship, in a while. So deciding whether I am entitled to that promotion or not is over. It has been decided by the Honorable Division Bench. All that was left to be relegated.
back for another departmental hearing where they again suppressed that there was vacancy. So we therefrom we came to the Central Administrative Tribunal, where also they suppressed. Thereafter, we had made an application under the RTI, Your Lordship. In that RTI, the reply which came showed that there were multiple vacancies at that relevant year. Because my exam was I have written the exam in the year 2006. Now, Your Lordship kindly allows me to take Your Lordship straight to the judgment of this Honorable Court, which is at page 41. May I place the judgment, Your Lordship? Page 41, Your Lordship. The petitioner is aggrieved by the decision of the Central Administrative Tribunal.
You had earlier indicated this.
Yes, Your Lordship. So that remains settled, that I am entitled. Kindly comes to page 43, bottom paragraph, Your Lordship. If it is found that the petitioner has not been appointed illegally or that his appointment is against a vacancy available for the general category, he will be paid all his dues from the date which he was terminated from service on 7th June 2010, which exactly I am claiming by way of this writ petition. In view of our
What
decision,
happened after this?
Your Lordship,
What happened after this order was passed?
after this order, the departmental hearing was conducted again. They suppressed that there was vacancy. I went before the Central Administrative Tribunal, the same fate. Now, Your Lordship, I'll show that pursuant to an application under RTI, I came to know that there were multiple vacancies. Your Lordship, kindly come to page 62. Your Lordship, my application is at page 60. The reply is at page 62. May I please? In response to your application dated 16 September 2020 under RTI Act, the information as sought for are furnished below. 1. As per available records, a copy of list of unfilled departmental vacancies of postman / mail guard cadre for the year 2006 is enclosed in Annexure 1. Copy of the rule is enclosed in Annexure 2. Now, Your Lordship kindly turns over the page. Your Lordship kindly sees that there are vacancies marked as OC. OC stands for open category, which is the general category, no reservation. Now, Your Lordship, there are 15 open category posts which stood vacant in that year.
You are from which district?
I am from Howrah, Your Lordship. Now, Your Lordship, there is a rule of the postal authorities that within the West Bengal circle, and since I am
Howrah is not mentioned here.
Yes, Your Lordship, which is why I am submitting that if there is no vacancy, if I am entitled to that promotion and there is no vacancy in that particular division, I ought to be given the opportunity to choose whether I want to go to another division and opt for that promotion. Your Lordship kindly sees that within that West Bengal.
What have you done?
Your Lordship.
What have you done?
Now, Your Lordship, they haven't given me that opportunity. If the authorities.
If you were aware of it, you should have opted it on your own accord.
Now, Your Lordship kindly sees this, but I have been demoted from that. That promotion was reversed way back in 2010. Now, Your Lordship, I came to know from RTI in the year 2021. Before that, the authorities has all along suppressed the fact that there were unfilled vacancies in that particular year in other divisions. Now, if the authorities have suppressed, I cannot go claim. What will I claim before the authority? The authorities are duty bound to make me aware. See, there are unfilled vacancies in the other divisions. If you choose to get take the promotion and go to other division, you may. And then if I don't act, then I am liable.
What happened?
But they never did that.
So after you came to know through the RTI, what was your step?
The whole saga when I for the second time went to the Central Administrative Tribunal. Hence, I have come before your lordship. That
what was the result of that proceeding?
your lordship, before the Central Administrative Tribunal also, they had suppressed that there were unfilled vacancies because
Why didn't you place this RTI?
your lordship, this came to my knowledge post the Central Administrative Tribunal's order. Post that order. Hence, I could not show before the Central Administrative Tribunal. Hence, I have come now before your lordship, only seeking for my entitlement, which has already been decided by the Honorable Division Bench of this Honorable Court, that I am entitled to the benefits from that.
Provided there is a vacancy.
Provided there is a vacancy. Now,
And there should not be any illegality.
No illegality. Now, your lordship, I have already been promoted later on. I have already been promoted. So, all I am claiming is that my back wages, my benefits to that post from June 2010, which has been endowed upon me by the Honorable Division Bench. May I once take your lordship to that order of the Honorable Division Bench?
Back wages should be given to you.
Yes, your lordship. Kindly comes to page 43. If it is found that the petitioner has not been appointed illegally or that his appointment is against vacancy available for general category. I have shown your lordship that there was vacancy in that relevant point of time. He will be paid all his dues from the date he was terminated from service, which means the reversing of that promotion on 7th of June 2010. Exactly from this date, I am seeking the benefits. Nothing.
But you have already been terminated.
No, your lordship. By way of this language here used is termination, but your lordship, I am still in service. The only what happened was that kindly seize that letter of appointment. That will clarify everything.
This order pertains to your case.
Yes, your lordship. Kindly.
Then how come it be all his dues from the date he was terminated from service?
Terminated means the promotion which was given to me, that promotion was reversed. Saying that no, we have miscalculated, there was no vacancy in the open category, the general category. Your lordship kindly comes to these are photocopy of the certified copy of the order. Kindly comes to page 38 and 39. Your lordship will find my name and all the details. The entire cause title is there, your lordship. Kindly comes to page 38 and page 39. The name of the petitioner appears. So it stands adjudicated. And only one more thing before my learned friend starts, only one thing. My learned friend had on the multiple previous occasions stated, no, he is of the provisional category. He is not entitled to anything. Your lordship, that has also been put to rest by this order. Kindly seize that same page 43. May I only show one paragraph which starts at page 42, the bottom paragraph. May I please? In our opinion, when the tribunal had concluded that the order passed against the petitioner under Rule 5.1 of the CCS-TS rules was incorrect, the tribunal ought to have set aside that order rather than relegating the petitioner to the authorities. Rule 5.1 of the CCS-TS rules can be invoked only in case of temporary government servant who is not in quasi-permanent service. The petitioner was not appointed temporarily. In fact, temporary service has been defined to mean any service in a temporary post under the Government of India. The petitioner was certainly not appointed to a temporary post. He was appointed to a permanent post. However, the appointment was provisional. In these circumstances, the petitioner could not have been terminated from the service by invoking Rule 5.1 of CCS-TS rules. So that is also been taken care of by the Honorable Division Bench.
But here also the word termination has
basically what happened was, since I was provisionally appointed, they had terminated my promotion, your lordship. If your lordship wishes, I can show all the documents. It's there in the writ petition. I was appointed as I was appointed provisionally. Then I gave an interdepartmental exam and I was promoted to the post of postman. But subsequently, they found that there was a miscalculation. They said that no, there is no vacancy to accommodate you pursuant to your rank in the Howrah division it was. Now, hence, they terminated my service from that permanent post and I was relegated back to the provisional service. But your lordship, the Honorable Division Bench has clearly stated that it's not a temporary post. So there, the provisional service cannot be treated as a temporary post. So that has also been put to rest. The only thing which remains is that I was appointed, my appointment was reversed, my promotion was reversed. So if there was any vacancy, that I am entitled to the benefit because there are subsequently I have been promoted again to that post. So all I am seeking is the benefits from 7th June 2010, which the Honorable Division Bench has already held in my favor. And I have shown that there was vacancy. So my learned friend most respectfully has only to reply to this, that whether there was vacancy or not.
Yes, sir. On the next date.
Your lordship,
Okay, Ashwin.
but your lordship kindly records that in the order that the scope of the writ petition is very short.
No, no, why?
Very. Then your lordship kindly gives a short date.
For the submission of learned advocates representing the petitioner, the learned advocate representing the respondent, which respondent?
Postal Authority.
Postal Authority is present. Next date we fixed on 25th of November for further hearing.
Your lordship may it appear for orders because your lordship had heard it at length.
Made my submission.
But he has to submit first.
Let him make the submissions because only to that point.
That I will.
Because
if he finishes that his submission on the next
your
date, maybe I'd fix it for
your
orders.
lordship kindly gives a shorter date because
September it can't be. October
Then
will you come? And November till 11th, I have my circuit at Andaman. That is the reason.
then yes, your lordship. I bow down.
57, last one matter.
My lord, Mr. Nilotpal Chatterjee is appearing in this matter on behalf of the state. My lord,
There is the affidavit in opposition.
affidavit in opposition, my lord. My lord, in the last order, my lord is directed to serve copy of writ and everything to the is the change brief 2017 matter. My lord,
Yes, he was present on the earlier date.
earlier date, my lord.
Mr. Chatterjee was present.
Yes, my lord.
You did not serve them a copy of the writ petition?
It was not served, my lord.
No.
Not served, my lord.
What are you saying?
My lord, due to non-communication, my lord, it was not served, my lord.
Not so.
My lord, we have a copy, my lord.
Why haven't you served a copy of the writ petition upon them?
My lord, due to non-communication, my lord.
What's non-communication?
We have a copy, my lord.
Who is the advocate on record?
But I am the advocate on record.
You are not present on the earlier date. What is your name?
Asif Iqbal, my lord.
So you were present in the court. Then what? Where is the scope for non-communication? Where is the scope for non-communication?
Lord, we have a copy, my lord. We have a copy, my lord. We have served it.
Serve it to him.
My lord.
Where is the copy of your exception?
My lord, already filed in the earlier.
You served them a copy also.
My lord.
There was a direction.
My lord.
Where is Mr. Chatterjee? You're not briefed in this
No,
matter.
I'm not brief, my lord. My lord, he's on his legs before courtroom number 11, my lord.
The learned advocate representing the petitioner has served the copy of the writ petition along with the copy of the exception to the learned advocate.
Gaurav Sengupta. I'm the junior.
Who happens to be the junior of learned advocate Mr. Nilotpal Chatterjee, who represents the state in the instant writ petition. Affidavit in opposition in compliance with the order dated 22nd of July is to be filed by 22nd of September. Next. Next date we fixed on 22nd of September. Order order FMA for orders आगे. আচ্ছা এই রেফারেল গুলো
Orders brief. We thought my lord will be taking up the claim cases.
No, yesterday I took the claim, I mean application. You don't have.
It's there in the card. Just that much of
You
time.
have it with you today.
Yes.
Lord, it's in the chamber, but right now.
Whatever it is.
We
Now you don't have.
Now,
Maybe
now,
after 2 p.m. you'll have it.
Yes.
Okay. Okay. Now who are there for the? Let us finish off this referral matters.
Oh, my lord can take up claim cases also.
Which one?
This
No.
claim-
There are from 334 till 338. The claim, the referral matters are there. The only orders will be passed. Let them. Acha, 334 you are there.
334.
335, 336,
But I'm there 335, 336, and 337.
337. And 338?
But I'm not there.
338?
338 is my
একই order আছে
38 not my
338 not.
338 এইখানে
35 to 37. Okay. And 34?
দেবাশিস মুখোপাধ্যায় কে আছে?
Mr. Bonik, you find out who are there in 334 and 338.
Today,
What do you mean by
Khuni,
today
lunch
itself?
lunch hour.
Find out. Acha, claim cases. his claim orders will not be taken.
I keep 1 or 2 weeks. By Thursday, I
99.
My lord, I am for the appellant in 99. It's a railway untoward incident case, my lord. In this case, already the matter was heard, so today it is fixed. If you honor, remember, your honor, in this case, they have admitted, my lord, that he was traveling. Only thing is that they are saying that it's a self-inflicted injury. Regarding that, your honor, I have to clarify, your honor. My lord, with my written argument, I have filed one Supreme Court judgment of Jamila.
Yes.
In that Jamila judgment, your honor, I am reading the main thing. We are of the considered view that the High Court gravely erred in holding that the applicants were not entitled to any compensation under Section 124A because the deceased had died by falling down from the train because of his own negligence. First, the case of the railway that the deceased Hafiz was standing at the open door of the train compartment in a negligent manner from where he fell down is entirely based on speculation. There is admittedly no eyewitness of the fall of the deceased from the train, and therefore there is absolutely no evidence to support the case of the railway that the accident took place in the manner suggested by it. Secondly, even if it were to be assumed that the deceased fell down from the train to his death due to his own negligence, it will not have any effect on the compensation payable under Section 124 of the Act. The manner in which the accident is sought to be reconstructed by the railway, the deceased was standing at the open door of the train compartment from where he fell down. It is called by the railway itself as negligence. Now, negligence of this kind, which is not very uncommon on Indian trains, is not the same thing as a criminal act mentioned in Clause C of the provision of Section 124A. A criminal act envisaged under Clause C must have an element of malicious intent or mens rea. Standing at the open door of the compartment of a running train may be a negligent act, even a rash act, but without anything else, it is not a criminal act, Your Honor. And this is the thing, my lord, they have the defense in the WS and in the written argument, they have taken the plea that he was standing on the open door. So they are considered this as a self-inflicted injury. Regarding this is a Jamila Supreme Court judgment, my lord. And one more thing, I have a Railway Act. In the Railway Act also, I am reading the main point. It is a matter of common knowledge that the railway tickets are issued from the one station to the other without even having any data as to whether the seats are available in the train for the passenger who is purchasing the ticket. The Department of Railway has never even thought on this aspect that whenever the tickets are to be issued at a railway station for a particular destination asked for the passenger, the official at that railway station should have the positive knowledge as to whether the passenger purchasing the ticket would be entitled to occupy a seat in a compartment of the train. The tickets are issued at random without even specifying whether the passenger has to travel by boarding the train on the rooftop or hanging on the steps of the compartment. Be that as it may, the railway department cannot be allowed to run away from its responsibility that a human being has to travel, and it is not the luggage which has to be carried and dumped. This is what Railway Act is saying, my lord. So regarding this, I have only to say this thing.
But
it has already been filed, my lord, I think.
No, but it is on record.
And my lord, we had also
Anything else you have to say?
Injury, my lord, we are relying on Section 123
C2.
C2 read with
124A.
124A and my lord, B, subclause B. This we have specified in our notes of submission. And we are also relying on a judgment, my lord. That is 2019 36572. My lord, not available in the docket to find there.
26 to 29.
2019 3 SCC 572. It's there.
And I have also filed 3 Supreme Court judgment that should be looked into it.
Paragraph 29, we have stated that capability in paragraph 5 of our written motion.
And my lord, I have
You're relying on paragraph 26 to 29 of the judgment.
And my lord, I have also submitted 3 Supreme Court judgment that should be taken care of, my lord. That is Dolly Rani sir, that is the latest judgment. One Reena Devi and Jamila, this is regarding the standing on the door. This is the judgment regarding standing on the door.
Okay. Hearing concluded, CV.
Thank you very much.
Hello.
Judgment is given, it should be in my name. Actually, in cause it is appearing Rajendra Kumar Mittal. So he was my father. So he has already died, and I have filed a new wakalatnama also, my.
So on the date of pronouncing that judgment, you remind that.
My lord.
Okay, I don't know because what they will type, I can't guarantee you now.
My lord, I will.
Yeah.
100. Page 36.
Yes.
That on 29th, fourth line on 29th August.
Non-involvement?
Non-involvement, first one, non-involvement, second one, annual income, assessment of annual income, and third one, grant of future.
Future prospect should not be granted.
The principal is about 1 year, so that's for 50, but the table granted 30%. And also for the in assessment of annually. Well, it will take some time.
Okay, no. Heard the submission of learned advocate representing the appellant insurance company. The learned advocate representing the respondent claimant is present. Next date we fixed on 26th of November. Appeal for?
Appeal for enhancement of award. After that, appeal was filed section delay. Lawsuit 9 days delay, but that have been explained in such way because of now before your lordship, the initially the on death of the mother of the victim, mother of the applicant, the father and the other lordship, the grandmother and grandfather also are the claimants before the learned tribunal. The learned tribunal passed the award in favor of the claimant, but against the award, nobody.
You come to 2549 days delay.
Lordship. But lordship kindly see the applicant at the time of filing of the case, he was minor. But you kindly see page 10 that I have annexed the birth certificate.
Then who had filed the claim application?
Father. Father and he was the minor on represented by his father, and other grandmother and grandfather also are the claimant before the learned tribunal. The learned tribunal also awarded in favor of the award in favor of the mother and father of the deceased. That is
so. Then what?
Then lordship, the father did not come before the Honorable High Court for challenging the award for enhancement. that enhancement is what I am paying in view of the policy. But only now after attaining the majority, the son has come before your lordship. Because of son, the age of the son at the time of judgment was 11 years. After that is attaining majority, they have come before your lordship. That is at least after 4 years. So as an
2549 is at least 4 years.
so after attainment of a majority, that is delay is only 1/4. Then delay is only 1/4
So father is still alive.
Father is still alive.
Father did not come.
Did not come. And the judgment passed by lordship kindly
And so the son, after attaining majority, has come.
has come. But he's the minor at the time of initial of the
So he was minor also at the time of filing of the claim application.
lordship. Lordship.
Then
He was minor.
father was representing him.
But this father is representing him.
Then
But lordship,
the father is still alive.
father is still alive.
Then
lordship, but the lordship,
father was waiting for the son to get major for filing the appeal.
that answer that I cannot extend, give that answer to that extent. But lordship, kindly come to
Did
the
they
judgment.
receive the money?
Yes, this is the money.
Whatever the amount granted by the land,
This is the money. Lordship, kindly see that who are the claimants before the learned tribunal. The grandfather and grandmother of the applicant before the lordship, also the claimant before the learned tribunal, and learned
They
tribunal
had received. Grandfather and
grandmother also received
all the whatever the apportionment granted by the land tribunal, we have satisfied that term.
Now, why have you come now?
Lordship, now I am coming from that the learned tribunal should not have passed any order in favor of the grandfather and grandmother. Number one, and the learned tribunal also decided the case by considering the lordship which kindly see that 3,000 per month without adhering the law of decided in the Punai Shetty and others, that ratio not as decided here.
That is why Punai Shetty is the main issue.
Yes, obviously the main issue. Obviously the main issue. But lordship, there is in the claim application, he said his mother income of rupees. His mother is not income of rupees. Lordship, kindly see here. Lordship, they also filed an opposition. They are not their opposition. Lordship will find it is not that they will be prejudiced if lordship will allow the claim case.
Yes,
because of my claim within the policy.
When did the accident take place?
Accident took place, lordship. I am supplying the date. It is lordship 16 to 2012.
12. Okay. And when was the judgment passed?
Award
passed 25 August 2013.
13. Okay. Heard the submission of the learned advocates presenting both the parties. Next date be fixed on 18th of November for orders.
Only for the condition of delay.
Everything together.
18th, sir.
Next.
Report. But I am for the respondent.
Where is Mr.
Niranjan Maiti, last occasion also, yesterday, this matter was made, not today only.
That before the matter. Ultimately, Mr. Niranjan Maiti is proceeding, and he's doing the case. Now, he's not well. He's not coming to court. Logically, we adjourn the matter for some time.
It's a
104.
আপনি তো the list. Not come. Just 2022. Unless and until 10, 12 years. But these matters don't go for local.
Hundred 506 is insurer's appeal and claimant's cross objection. Milord Mr. Ashik Mondal was there. Lordship on the last day wanted to dispose of the appeal in the favor of insurance company on the ground of non-involvement. Lord, I said that Lord that he's praying for the reprieve for the day. Lordship said no, let's fix it up Milord after a week. Milord, it is pending since then. Mr. Ashik Mondal was there, Milord. So Lordship will kindly keep it up Milord 1 day before vacation. If it is taken up, otherwise after
But
vacation.
then your Mr. Ashik Mandal is not coming.
No, he's not coming. No, today, Milord, we are on 2nd. We will be, Milord.
In any case, he can appear online.
Milord, I don't know. Perhaps he is not in a position to.
Is in station?
Yes, he is in the station.
Then-
Yes, he is not well, Milord. But
That is.
Milord, Milord, for this case, Milord, for other cases, your Lordship will kindly keep it up as far as Mr. Mondal is concerned after vacation. But for this case, Milord, just keep it 1 day before vacation. If it is taken up, otherwise after vacation.
On the prayer of learned advocate representing the affluent insurance company, let the matter be fixed on 24th of September, which is the last date.
Milord,
6.
26.
The 24th of September, if you come.
Lordship.
But their matters are getting piled up. Anyway, next.
107.
There was a direction on defects. I do not know my learned friend has removed the defects or not. Last order, your Lordship kindly peruse.
What were the defects?
In the judgment of the lower court, 2 names it was appearing, 2 claimants were there, but in our record one claimant. Out of that one claimant,
Name of a sole claimant. You have not yet removed the defect.
the petition of parties has been filed, and the defects cannot be removed until
What is she saying, Matt?
Can be allowed. Addition of party application can be allowed. It is can, my lord, 2.
Has she mentioned there about this?
Yes, yes. There were 2 applicants before the tribunal, 1 before your Lordship's court. So defect was detected that both are not there. That is why, my lord, then
Show me that judgment of the tribunal.
This is dated my 29th of April 2019.
Yes, sir, but the copy of the judgment is not. Yes.
Rahul Roy and others.
Rahul Roy and others. Now, who will find out who are the others?
That is my learned friend to.
Others, whether it is 1, 2, or 3. Then she has to file the trial court records first. A trial court record call for Kutta with them. Because
Maybe more than 1.
more than 1. Because the ordering portion also doesn't say, it just says dismissed.
And I do not know what defects has been recorded by noted by the department.
The same, that you have not mentioned the names of all the.
That even your Lordship kindly call for the record.
the Learned Register Judicial Services to call for the trial court records from the court of the, which is a court, sir, Railway Claims Tribunal. Prior to the next set of hearing, special messenger cost is to be borne by the learned advocate, is to be deposited by the learned advocate representing the appellant claimant within 7 days at the department. Next date fixed on 21st of November. Two PM after the other matters are taken up, I'll go with the orders. For orders. For orders. You get your briefs.
Please assign matter, item number 1.
I appeal for the petitioner's matter, my lord. My lord, last occasion, Lord was kind enough to direct me to introduce the what is, my lord, ESI code applies to BSNL or not. Now, my lord, apart from that, my first concern was that, my lord, BSNL, for the sake of argument, let's say, my lord, BSNL is bound to pay ESI code for the sake of argument. But, my lord, in terms of the contract, my lord, if the contractor has already paid the ESI code and upon which been satisfied, my lord, BSNL has paid to the contractor, I would like to draw lordship's attention to, my lord, the supplementary affidavit where I have annexed the payment made by the contractor under ESI code to the ESI. It is already annexed. Ekটু দেবেন supplementary 2 number supplementary there.
Which page?
My lord, very big. Page 132. Onward, my lord. Employee State Insurance Corporation.
You show me the relevant portion.
All of the challans. All of the challans made by the contractor, my lord. These are the various challans.
Yes.
My lord, till page 236. These are all the challans of the contractor which they have already paid to the ESI. The copy was supplied to the BSNL. On being satisfied that they have paid, we have reimbursed their payment. So once already they have paid, my lord, why BSNL will pay once again, my lord?
Okay.
May I?
Yes, sir.
But first of all, my learned friend on the last occasion has said, Lord, BSNL will not come under the purview of the ESI because they have their own scheme and all that. Your Lordship, Lord, after hearing my learned friend, your Lordship has said that show me the documents where BSNL on other courts they are complying. So, my Lord, I have brought that, Lord. Yes, Lord. Now. My lord, these are the 3 courts I am showing. Judge Sahib একটা দেবেন এটা, একটা দেবেন এটা. So my lord, directly they are paying, not contractors and all that. What my lord said.
No, but then here is
3 courts, my lord, and other separate court, Lord. This is nothing to do with this case, but they are complying with other courts also.
no, sir. Here it says number of employees. Number of employees. Now, in this matter, perhaps it's the contractor. Contractor is not an employee of BSNL.
No, contractor, not the contractor's employee is there.
Contractor's employee.
Employee engaged by the contractor for the work, my lord, assigned to them.
Yes. So there must have been an agreement with BSNL and the contractor.
Yes, that is there.
That is there.
So it must have mentioned that if the workers or the employees or whatever you call under the contractor itself will contribute.
Yes.
And then get reimbursed.
Yes.
Then
here it has not been done. For that reason, my lord, we have assessed the dues. My lord, what my lord, and my lord, more so, my lord.
What about those challans, sir?
My lord, I'm saying that more so. If my learned friend is raising dispute with regard to payments and all that, my lord, there is my lord, appropriate forum for that. My lord, 75 your lord, after an order which will be passed on under 45 AA of the 70. All disputes, kindly see, Lord, here my learned friend cannot maintain this, Lord, because he is disputing.
So no, now what is your contention? That jurisdiction is an issue.
Yes, section is also issue, but I am saying that after there is a statutory appeal for that.
which my lord cannot undertake the reproduction in view of section 75 of the Act, Lord. There is a specific provision, Lord, for the statute provide appeal, section 75. 75. Then we will do pass your report. 75, Lord. Section 75. 56 of us, huh? 75. But should I give my book?
No, I've seen.
My lord, your consequences, Lord. Here it has been said, Lord, matters to be 75. Matters decided by employed insurance court if any question or dispute arises to it. There is a disputed question of facts, Lord, now. Whether any person is an employee within the meaning of this act or.
Yes, I've seen that.
You're also saying, Lord. So, where there is an appropriate forum. Under the act, Lord, that is a contract.
Sir, can you show me that portion in the agreement where you had said that the BSNL will.
And you also kindly sent the last order passed by the Justice Raja Washington, where they sent for remarks. And here he has not produced any documents, Lord. Two things, my Lord, because he has elaborately made his submission. In this matter, my Lord, on remand, this order has been passed. If your Lordship kindly takes, my Lord, P12 61, page 61, my Lord. Page 61 of the Writ petition, my Lord. Writ petition, and before that, your Lordship kindly takes, my Lord, 59. First of all, your Lordship kindly takes, my Lord, page 59. Page 59 of the Writ petition, my Lord. Page 59, my Lord, that's, my Lord, order dated 12th January 2023.
Okay, I've seen.
Your also seen, Lord, it was remanded back, and then, my Lord, it was order was passed.
241 now?
Supplement, volume 2, volume 1, volume 2, 241, my Lord. Point number 21, my Lord. Bottom. Clause 21, bottom.
Okay.
My Lord, kindly, my Lord, kindly. Page 61 and 62.
Of
the Writ petition itself, my Lord. Page 61. On remand, this order has been passed under section 45AA of the Act. Now, your Lordship, can it takes, my Lord, second page. My Lord, second page at the bottom, my Lord, middle portion, my Lordship, can it takes.
Just read it, sir.
Well, this is my Lord, for my satisfaction.
I told you, I have read it.
Actually, my Lord, for my satisfaction, one thing, Lord, should I?
I have seen it. I've seen it, sir.
Your Lord's question. My Lord, so, my Lord, in my most.
I've been asked to approach the appellate authority.
Appellate authority, and appellate authority has passed the order where he has not, my Lord, complied with, my Lord, that direction or instruction passed given by the authority. If that's why I am showing page 62. Page 62 is very important, my Lord, because my Lord, the employer was asked to produce the following records and documents where he has not shown, my Lord. Trial balance for the period of 45A order in respect of BSNL Jadavpur exchange only. Ledger bills and vouchers in respect of the accounting years involved wages of contractual and outsourced labor pertaining to BSNL Jadavpur exchange for the period of 45A order. The employer submitted only trial balance for Jadavpur region, consists 10 exchanges instead of Jadavpur exchange. And that too for financial year 2009 and 10 only. Since the employer failed to produce any of the documents mentioned above, the amount of wages paid to contractual and outsourced laborers engaged in Jadavpur exchange for the period February 10 to August 2015 could not be ascertained. So, Lordship, can you say this is very clear? During my Lord, I was present there, my Lord. My Lord, all the documents are under the custody, my Lord. It is, my Lord, I'm specifying the register. It is C6 register of the payment, my Lord, which they have, and it contains.
So from 2010 to 2015, if the challans that had not been placed before you being the BSNL, right? that this ought to have been produced by the contractor to you. So ask the contractor to produce.
I've already, my lord, annexed. If I can annex here, my lord, very well, I have already produced there, my lord.
So you are produce here also?
These are the challenges, my lord.
2010 to 2015. The ones
not, my lord, it's a huge documents, my lord. My lord, find it is yes, 2010 is there, my lord, 11 is there.
These are all 2010, sir. 10, 11, 10, 11.
For that very reason, if my lord kindly direct them to produce C6 register, my lord. It contains all the documents. C6. I'm specifying, my lord. Register number C6. Let them produce. It contains all the documents.
Well, here order shows below something, and my lord is making submission.
I have gone through their
So, my lord,
records,
best, my lord, my respectful submission, best course would be, my lord, lordship kindly my lord, direct them to, my lord, to approach, my lord, my lord, under section 75, that appellate authority, my lord, of 45A, or, my lord, your lordship can, my lord, if my land friend says
you filed that C6 register and you filed till 2015, right? Then we'll see what.
My lord.
But the submission of learned advocates representing the respective parties, the learned advocate representing the petitioner is to file a supplementary affidavit annexing the challenge with regard to amount of wages paid to contractual and outsourced laborers engaged in Jadavpur exchange for the period February 2010 to August 2015. The learned advocate
of Jadavpur exchange, my lord.
the learned advocate representing the respondent is to place the C6 register on the next
register of payments.
Register of
payments.
C6 register of payments.
In respect of Jadavpur exchange.
In respect of Jadavpur exchange. Next date we fixed on 26th of November.
26th November. Yes. Wait. After the
সরকারি মামলা
আমাদের
For judgment, item number 1 and 2. CRA 88 of 2009 and CRA 89 of 2009.
Mr. Manna was here.
P WPA 6326 of 2009.
Goes with the direction that the respondent authorities will be reconsidering the case of removal of petitioner documents.
Item number 4, PRA 158 of 2013. Item number 5, WPA 3375 of 2013. Six, PRR 4079 of 2013.
Allowed.
7, PRR 3878 of 2014.
Yes. Against that paltry sum. Kept it pending for such a long time. Next.
Item number 8, WPA 25143 of 2014. Nine, WPA 8888 of 2016.
My lordship, I am for the item number 9, respondent number 225.
The interest has to be paid accordingly disposed of.
10, WPA 1
My lordship.
2016.
Allowed.
11, WPA 30572 of 2016.
I am appealing for the respondent, my lord.
Disposed of with a further direction upon the review committee. Consideration by the review committee as well as the appointing.
12, WPA 16847 of 2017.
Is that disposed of?
14, WPA 23024 of 2019.
Letter dated 6th of November 2019, such issued by respondents. Are set aside. Respondents have to provide compassionate appointment.
14, WPA 13230 of 2021.
Where for the respondents.
Item number 1 and 2,
My lord, CAV was recalled earlier. My lord, CAV was recalled and a notice was issued upon the opposite parties accused of.
Sir, on that date, we
Well, subsequently, it was it came in the list, my lord.
that date we were not there. Moreover, you have come against an order of arbitration. Part payment was also there. Two, three checks were also cleared. Out of 5 lakhs, 3 lakhs 50,000 already received. Next.
301, item number 301.
He knows very well.
There is only one later.
The printout is outside me. Hello.
Yes, sir.
There was a conviction of 5 years, 5 years. Total 9 cases, charge was framed by the 142 and 149,
That's me.
Sentence.
My lord, so far as Jalar and Rajbali, my lord, they were convicted for 5 years for 307, 149. And my lord,
It doesn't have a paper book.
was
No, paper book is na. It
was TRR because the order was challenged before the appeal was prepared before the landed sessions court.
Initially, the trial was held by additional assistant sessions judge. Thereafter, appeal was preferred before additional sessions judge. This is the second appeal. That is why revision has been filed.
Can you file written notes and finish it off?
Yes, yes.
The learned advocate representing the petitioner as well as the state are present. Written notes to be filed on the next date of hearing. Next date be fixed on 27th of November.
November.
Okay.
302. 302 is fixed matter for filing our written notes of arguments.
Lordship has heard that matter, my lord. I have handed over the case diary also, my lord. That.
Okay. Ashwin. Written notes filed by the learned advocate representing the petitioner be kept on record. Hearing concluded, CAV.
Grateful. Grateful.
Lordship, in item 303, I am for the opposite party, led by Mr. Opalok Basu. Kindly give us a short pass over, Your Lordship. He's on his legs before court number 446, Your Lordship.
None appear to represent either of the parties. Next date be fixed on 28th of November. Next.
Relating to the unauthorized construction. Now, I will draw your lordship's attention on our January 2025 order. Then your lordship was pleased to give a direction upon the Panchayat Pradhan to submit a report relating to the unauthorized construction on plot number 778. I am concerned with plot number 778.
Now, sir, there was to you were to file documents with regard to your individual ownership.
Yes, and I have annexed these documents. All documents I have annexed.
No. Before the Pradhan, you have to produce those documents.
No.
We have asked for those documents by
Your
giving
lordship
state.
fixed an order as regards the ownership. I have to produce the documents. I have annexed all these documents.
Where is it?
Yes, in the writ petitions. And the petitioners purchased the land about 24 decimal in respect of plot number 778. Now, my lord, my learned friend's client, the private respondent.
There is a dispute with the number of the plot.
Yes. He has got the patta on 780.
What
I am not concerned. Let me make my submission. I am not concerned with the 780. I am the owner in respect of plot number 778. To that effect, I have annexed this deed. I annexed the record of rights. My contention that the private respondents had made the unauthorized construction on plot number 778. 778. We raised this objection before the Pradhan. I have annexed these documents. If your lordship desire, I can show these documents here and now.
Documents, I'll fix it for orders then.
One second.
Yes.
Last occasion, he relied upon a letter issued by the Pradhan, wherein he has stated that the dag number 778 without permission, there is a Pakabadi Nirvan Koriya.
Yes.
This was the document which was sent. We have inquired whether this was sent, prepared by the Pradhan or not. The Pradhan has said that the signature, they are in the office, there are, we have to keep certain letter pads. By taking this letter pad, they have printed this thing and the signature of the Pradhan. Now,
sir,
another thing, wait. Another thing, when we issue any letter, that goes into our register with memo number. This memo number is not present in my register.
Now, why you are not submitting the report?
So how he is
passed an order.
So this document is a manufactured document by the petitioner, read petitioner. Can you see the memo number? There is a memo number. I maintain my register. Whenever I issue a letter, that goes in my register. That certain this with this memo number, letter was. No, this memo number, there is no entry in my register book.
I cannot understand when a court passed an order.
No, you have to
make an inspection and Pradhan will submit the report. Why you are not submitting the report in compliance with the order of this court?
First, you come with
Why you are
clean
showing
hands.
this document?
You have to come with clean hands. You are saying that Pradhan
you
has
comply with the order of
no,
this court.
certainly not.
You
are
comply.
saying that the Pradhan has issued this letter.
You will not
have
comply with the order
manufactured
of
this
this court.
letter and given to the court.
Where this inspection?
Ashun.
Totally a civil dispute. The Pradhan will go into
Civil dispute?
Yes, certainly. Pradhan will go and determine.
First
who
of
is
go to the
fraud or not.
provision. Go to the provision. Then make
I have
argument.
gone through the provision.
Mr. Ganguly. For the submission of learned advocates representing the respective parties, next date be fixed on 24th of November for orders. 24th of November for orders. There were 4 orders done.
And meanwhile, my lord, they will submit the report in compliance to lordship's order. They are not submitting the report.
Let them not serve it, submit the report. The order sheet will reflect. The order will reflect.
My lord, we have called them, both the parties, come with the documents. Let them show the documents. My lord, I will
There is
decide.
court's order.
My lord, I will decide. My lord, I am the BLR.
Sir, I have many matters in the list, sir.
Item number 262. 262.
Yes, sir. CO গুলো তো ডাকতে হবে না? Yes, sir.
For enhancement of the award. The incident of 2001. Incident of 2001.
Yes.
Lord, a boy of 23 years.
Yes.
He claimed his income as 3,000 per month from his tuition and business.
Huh?
From tuition and business.
Age of the boy?
23 years.
Yes.
Income claim 3,000 per month. The terminal taken, Lord, 2,000 per month. And a multiplier taken on the age of the mother. Mother is the only claimant. Mother is the only claimant.
23 is the age of the victim.
Yes.
Multiply of the age of
18. Multiplier will be 18.
Multiplier 18.
Then mother
income minor all right.
Mother
one accident.
No, income lots are আমাকে বলতে হবে না multiplier taken 15, it will be 18. I'm not on third deducted, it will be not 50%. Though my elephant do not pay for any appeal. Interest has not been allowed on in default interest. So now, Lord, the future percent will come. 40% future percent will come. Now I am paying, Lord, 3,000 may be taken.
Next.
In default.
না ফিউচার প্রসপেক্ট অ্যাড করো
40
হ্যাঁ না প্লাস তোমার ইয়ে করো ওই 30,000
But I'm
So it seems your matter will take some time.
not big matter, my lord. I will praise the judgment. My lord has read this judgment on previous occasion also. Lord, page 35.
Sir, I'll take this matter tomorrow, sir. It will be a bit, number will reduce as far as the forwarders of FMA. I'll ask them to keep your matter on top.
But then day after tomorrow.
Day after tomorrow?
At 2 p.m. Lord,
Yes. But your other side is also not there.
Was there, Lord. She was. I will inform her.
Okay. The learned advocate representing the appellant is present. None appears to represent the respondent, the Union of India. Let the matter be fixed under the heading for orders on 4th of September. Next.
Report 265.
Lord, this is an insurance appeal with the cross objection of my learned friend claimant. It's a death case, my lord.
Because there are CRR also. Now, according to you, on 7th of April, number of mobile 6, it became 0. Owner stated of non-involvement.
Yes, my lord.
Your lordship is nodding.
Absolutely, your lordship is correct. And after hearing your lordship has been pleased to fix the matter under order, there is the issue regarding involvement. My lord, 2 days delay in lodging FIR.
Okay. And for you, enhancement for 3,000 to 4,000. For what?
Yes, ma'am.
For why?
Because
my lord,
he's
the
here.
accident took place 2013. Even if my lord, the employer has come and deposed, his income is 5,600.
It's your
Chart, your lordship will kindly follow this chart strictly. My
2013.
2013. Milord, your lordship will kindly, Milord, report the submission. I'll just indicate, Milord, why, Milord, I had come up before this honorable court, Milord. Milord, as far as Milord 4,000 is concerned, and as far as future prospect is concerned, Milord, let
calculate.
But Milord, your lordship will kindly, Milord, I'll just indicate, your lordship will kindly deal with that particular part. Milord, accident on 7th of April.
No, that I will dictate that.
Milord, on 9th of April.
You show me the charge sheet?
Yes.
Milord.
Milord, FIR, Milord, with the charge sheet is page 51.
Yes.
Wait.
And 52 is the operating part.
Now this handwriting is so difficult.
Milord, I was, Milord, indicating to your lordship. Milord, page 49. Milord, page 49, Milord, the very last sentence of this general diary. Milord, this is lost by the widow. Milord, this number is 0998.
0998.
Milord has seen that.
0998, yes.
Milord, this is 2 days after the accident. Milord, this culminates in the FIR. Next page. At the top, Milord, 0998. It is there. So, Milord, now, accident on 7th. Milord,
FIR or charge sheet?
Milord, sorry, Milord, charge sheet, Milord. Milord, this journal diary, Milord, I'm sorry. Milord, journal diary, accident on 7th, on 9th, Milord.
Now you show me the Caesar list.
Milord, Caesar list, that is subsequently, Milord, that all has been managed. Milord, why I'm saying so, Milord, why it has been implanted. Milord, Caesar list is correct.
6998.
Caesar list is 6. Charge sheet is 6. I am only on the 0 part. Milord, 0, 2 days after the accident, widow goes and says that it is 0. Milord, the eyewitness, the sole eyewitness to the accident, if my lord, kindly, Milord, come to page number, Milord, 17, 17. Eyewitness.
Eyewitness doesn't even say anything
Milord,
about the
page,
number.
I'm sorry, Milord, page 14. I'm sorry, Milord, 17 was the employer. Page 14, Milord. The relevant part is at 15 and 16.
Eyewitness also says so.
Yes.
6998.
Yes. But Milord, your lordship will kindly see, Milord.
Sir, is this court sitting on evidence?
Milord, eyewitness says, Milord, at page number 16, cross-examination.
Sir, the
Fourth
other
line, I told the police on the date of accident the number of the vehicle. Huh?
What to do? The entire record is against you.
And Malad, on behalf of now, you can company.
I will elaborately express your
Lordship.
disapproval at application under section 166. was for the
then written it down. The enhancement principal, Lord, by my lord's order is of 2,82,500.
আচ্ছা লিখুন the
যেমন ছিল তেমনি থাকবে।
It is a case of under 163A, Landed Tribunal granted 3,26,000.
when did the accident occur?
Accident occurred on 7th February 2011.
7 February 2000.
11.
When was the judgment produced?
Judgment produced on 7th February 2019.
Page 27.
7 February 2019.
Yes. তোমার দরকার নেই।
Interest.
They must have received 3,20,000.
Plus interest.
26,000 plus interest, yes. Next.
This is my appeal. This is a case, my lord. Injured of 8 years old boy, my lord. And his leg has been amputated. My lord, at first, my lord, kindly see page 20.
Why have you come?
Lord, I have come for enhancement.
Enhancement of what?
Enhancement, my lord, the income has been taken 3,000. Accident took place 2019. And my lord, 1/3 has been deducted. 1/3. This is in case of a, my lord, death case, that deduction will come, my lord. Thereafter, again, my lord, 30% has been added towards future prospect. It will be, my lord, 40%.
Age of the victim?
8 years.
Huh?
8 years. Amputation, my lord. Leg has been amputated.
What is the amount of compensation granted?
My lord, 5,41,840. no computation has been granted towards my lord property claim. And my lord, your losses only 30,000 has been given, my lord, pain and suffering. And loss of amenity is 36,000 only. My lord, page 29, your losses will find.
Page
29.
amputation of right leg.
Of leg, yes. My lord, here, my lord, kindly see disability certificate, my lord, page 72.
The annual income 36,000 deducting 1/3. You failed to provide medical documents.
But document, yes, sir. But some document, no documents provided, therefore lump sum amount has been given. Total medical expenses.
Where is the disability certificate?
It's 72 page.
Huh?
It's 72, my lord. 72, 73.
Amputation of
Right leg.
Right leg.
any scope for getting a prosthetic?
Oh, yes. No, my lord, amount has been given. And my lord, your lordships will find that in a case of a my lord minor.
My lord, may I?
Minor injury, your lordship has, in a case of a minor death, has taken my lord minimum wages. 2019, my lord, accident took place, my lord. I am leaving it. In 2019, minimum wages, unskilled labor was 10,000 minimum.
My lord will just kindly go through the observation of Supreme Court, my lord. This is the sorry. This is the judgment of Kurwan Ansari. The last paragraph, para 39, my lord. It says that 30,000 should be, it's the total annual income, which should be taken into paragraph 39, my lord. And no future prospect has been granted.
That is death case.
This is, I'm sorry, this it's a second. আপনি বলবেন?
Have to বলে দিই, my lord.
আচ্ছা, let him finish, man.
Yes, my lord. Your lordship kindly see these two decisions. My lord, after considering these two decisions, your lordship also, my lord, taken my lord Kajol. And this is the last one.
Kajol is, it's absolute, the child became, her IQ level went down, it's 10% disability, my lord.
Yes.
Herein it's 60%. And these are the other two judgments, my lord, of very recent of Honorable Supreme Court, my lord, wherein Kishan Gopal has been affirmed and no future prospect has been granted.
But
and the
case, my lord, 2024 for TSE 715. 715, my lord. Here, my lord, future prospect has been granted. Entire thing, my lord, has been considered. This is also, my lord, minor injuries case. After considering these two decisions, your lordship has been pleased to pass one decision that has been, my lord, decided by your lordship in the case of May 1037 of 2024. On 30th January 2025, your lordship has been pleased to.
My lord, these are the two other judgments of my lord. Paragraph 16 in Meena Devi and in both paragraph 16, my lord. Tribunal had, I have given three. One is Kishan Gopal, one is Meena Devi, and one is Kurwan Ansari. And in all three, my lord, no future prospect has been granted, and tribunal has granted 30% future prospect. So they have already received more if we consider these three judgments. And Kajol, it's not applicable in this case, my lord, because Kajol's, in that case, my lord, the child, if I am not wrong, the child became absolutely
100%,
100%, 100%.
80% disability was there, taken 100%.
Yes.
In this case, your lordship will
it was a 9-year-old child. The child had hysteria, and it was 100%. That's not applicable in this case, my lord. In my lord's, the order that my lord had passed, my lord, in that judgment, there is no mention of any judgment, any other Supreme Court judgment. I've read that judgment.
Yes, my lord, but these two judgment has been considered and taken, my lord.
They have already received the future prospect. My lord will kindly not grant
40%, my lord. FMA 1037 of 2024, 30th January 2025. Your lordship has been pleased to, my lord.
And as far as I'm sorry. Which one, my lord? No, that doesn't go in my favor. I'll only rely on the portion which goes in my favor. And
Yes.
that is only this one. I'll take it back. But the other two?
To Kurban answer is also death case.
Kurban is also death, my lord.
Principal?
And on the point of non-pecuniary, that total.
Yes.
I leave it to my lord, but I just wanted to point out, my lord, that in case of a minor, this is the observation of the Honorable Supreme Court. In case of death, no doubt, but the principle that a total sum of rupees 30,000 per annum had been considered. And as far as the non-pecuniary damages are, my lord. No. Only. Then we both will take back all the judgments.
My lord.
Next. Grateful, madam. Mr. Paul, keep it very crisp.
163 application, my lord.
163A.
Yes.
Chanchal. How much was granted?
Granted rupees 1,65,000 together with interest, 6% interest.
How, tell me. What?
1,65,000 together with 6% interest. Tribunal has already been
Okay.
granted. Further entitled, my lord, 3,35,000.
I see.
To 17th March
March
2022.
22. The
3,35,000.
3,35,000 further.
Along with interest at the rate of 6%. Next.
Date of filing is 21st January 2018.
Next.
Page 31.
31.
Yes. 4 and 5.
31.
My lord,
There are two numbers. Which one?
the
First one.
bigger form, my lord, not handwriting. Not handwriting.
Page 31.
Not handwriting.
Yes, sir.
Compensation on the ground of
Vivekananda Hospital. That one.
Exactly.
Yes.
31 is, my lord, this is grounds. That is the compensation on the ground of occupation. This is as business by the learned tribunal, income tax return.
So which page are you saying? This one? Then?
First one.
Type copy.
Type copy.
Type copy 31.
So here type copy 31 is this only. এটা কোনটা দিল? দুটো copy. আচ্ছা, you are on the grounds.
Yes.
You are saying income tax return should not be relied upon.
Right upon. And the, my lord, then the second one is the page 31, my lord.
5. My lord, ground number 5.
Ground number 5.
Yes.
interest period should be taken as because it was the dismiss for default. So interest, that is the, that true ground. And there is no driving license. That's the ground.
No, this, where is the judgment?
Judgment, yes.
Judgment is page 21, 24, my lord, Lordship, let's see. 21 on
20?
page
21. No. The decisions with reasons is from page 20.
21.
From page 20?
Kindly see page 24.
Yes.
Good.
My lord, page 23, my lord.
11 page.
11 page 23. Onwards.
What are these? He's saying that income tax return.
Yes.
That is page 24.
And my lord, the question which has been raised by the insurance company, that is page 26, bottom portion. My lord, paragraph 32 of judgment. Inner page 10 of the judgment, my lord. And inner page 10, my lord, has been written bottom portion.
Censor.
No ground. Yes.
Entire amount.
Along with interest.
Yes.
Next.
Ashik Mondal is there. This matter.
But Mr. Ashik Mondal is there.
Yes, yes.
Then what? No, then in one case, Mr. Singh, on that date, Mr. Ashik Mondal.
After that,
So, what was the date, Mr. Singh? When the learned advocate representing the appellant insurance company is present and appeared to represent the respondent claimants. Next date we fixed on 24th.
24th of September.
24th of September for others.
My lord, I am for the respondent claimant.
Where is the other one? Where is he? Where is Mr. Ganguly?
The colleague said he is coming, my lord.
No, পরেরটা doctor. 273.
That has been heard by your lordship and
Who is your other side?
Mr. Rajiv Basu just can you make it only pass over second matter is my matter. Can you taken up this matter? This is also Mr. Ganguly. Can we pass over two matters for the time being also? Just what can be done? I am ready, but one this Mr. Rajiv Basu and Homeopathy Ganguly. So kindly just only pass over and calling.
This CRR, they are also on the list.
This matter is three occasions lordship heard the matter. So kindly, the injury case is suffering both of
Then if you were so particular, why didn't you keep that person?
yes, lordship. Yes.
এটা কোনটা? 272. You get your other side in this in between.
Lordship, this is
Keep it very crisp,
yes,
very short and crisp.
Your Lordship, this is an appeal which we have filed on twofold grounds, Your Lordship. Your Lordship, first of all, there is a dispute regarding the car involved in the said accident. Your Lordship will find in the judgment portion.
Which page?
Judgment page number 26, Your Lordship.
What is it?
Page 25, Your Lordship. In course of the argument, learned is a third paragraph.
You show me the evidence first. What is it?
It's the
Registration number such and such of a truck is such and such. Both seized your vehicles bearing such and such were seized. What are you saying? Non-involvement?
yes, sir. This is the my first ground.
On which ground?
This is the my submission is on the FIR. If your lordship kindly come to the FIR, go to the FIR. It will be there's no car, no truck has been mentioned. When the charge sheet is being filed by the police, in the charge sheet there is no mention of the
Complaint in which page?
lordship. Yes, lordship, kindly come to page number 37.
37. This is the complaint.
FIR. And the complaint is then starts in from 42 your lord 43 your lordship.
43.
Is it?
Where is the translated copy? You mean to say the complaint as well as the FIR did not mention the
Written
number?
complaint, the FIR.
Did not mention the number of the offending vehicle.
No, there's no mentioning of any offense.
And it came in the charge sheet.
It came, but in the charge sheet, if your lordship will come from the judgment, it is crystal clear that there's a mistake in the charge sheet, which the court has ignored. We have categorically showed that the claim petition of the registration number of the offending vehicle is WB 912522 and it's a truck. But according to charge sheet exhibit 2, the registration number WB 912522 is a motorcycle and the registration number of a truck is BR 37W2785, which is from the exhibit number 3, exhibit number 31. Both Caesar list it appears that two vehicles bearing
Where
number.
is the evidence of the eyewitness?
Should kindly come to দিয়েছে তো মনে হচ্ছে না লাগানো আছে eyewitness
Eyewitness is not there.
no, he has not put it.
PW1.
Deposition of PW1, it's PW2 is 15, page number 15 to 17, but page number 15 to 17, Your Lordship.
Yes, PW2 is the eyewitness.
Yes. Page number 15.
So he has mention of the truck.
Yes. Lordship, there is an ambiguity regarding the
Truck and the motorcycle.
motorcycle. So that is
So what did the charge sheet say?
charge sheet say is in charge sheet. Kindly come to this charge sheet, Your Lordship. It is in page number 46, Your Lordship. Page number 46.
So both were
Yes.
seized.
Both were seized. Then, Your Lordship, there is another thing comes out.
Both were seized and the charge sheet was filed against the truck. Then why are you saying all these things?
Your Lordship, then I'm coming to the point. Your Lordship, the point is the truck was standing in the road. The motorcycle hit it. And it should be a contributory negligence, wherein both the insurance company has not been made party. And Your Lord,
So this is a hearing matter. Why did you get it fixed under orders?
this is the only ground, and other is the quantum which could be solved by Your Lordship right now. But this
No, but right.
Lordship, the quantum part, Your Lordship. Yes, Your Lordship. If Your Lordship kindly come to the judgment, Your Lordship, the interest part is 7.5% per annum, which, and Your Lordship, on other heads, Your Lordship, the income of the victim has been considered as 7,375, though they have and he was doing business. There's no trade license, nothing has been given, no sort of evidence has been given to prove his income. So my humble submission, notional incomes to be considered, which should be 6,000 to that effect, Your Lordship. And Your Lordship, the interest part and also the total on other heads. Nothing, Your Lordship. That's it, Your Lordship. This is a humble submission, Your Lordship. Interest to be reduced.
How much amount have you deposited?
Your Lordship, I have deposited. I have given
Write
the
it,
slip. I
write
was
it.
mentioned.
Opposition. 273. To the case, Nasib heard the matter. I have challenged that only the quantum kindly, Nasib, kindly turn to page 152 of
Who
the.
has filed?
I filed the.
Income not considered properly, multiplier not applied, future prospect not granted, no contributory negligence. And you said father's motorcycle, no permission from father.
Is the getting the license only for 15 days.
Today.
He did not prefer any appeal, I was satisfied.
Hmm?
He did not prefer any appeal, I was satisfied.
Then why have you come? For claiming more?
As for enhancement, there is observation of learned tribunal not claiming property.
Okay. Then tomorrow. Because I have, this CRR has day after tomorrow. Chanchan. For the submission of learned advocates representing both the parties and the matter be fixed on 4th of September under the heading for others. So CRRs are there. Yes. For you, it's over for the day.
So next matter is my matter.
Hey. This is the punishment for that 1 hour.
Otherwise, I will have to come serially. I don't know, fixed on next day. Walk on, otherwise, then I will come on serially.
In any case, you will come serially. Do the calculation properly. That was the portion you should have indicated first, other than deviations. CRR. देखिए রেকর্ডটা
In cases like today, my lord, and then for order.
A bit of claim cases and thereafter for orders. Because otherwise,
Few stay matters. The stay matters, the stay. The stay already is completely stopped for few days, Your Lordship.
what is he saying?
The stay matters.
They're in the list.
Those are not getting listed, Your Lordship. As to be mentioned, only for the stay matters.
First, you just let us reduce the list first.
305.
You come on a Saturday then for stay applications? You will come? No, I'm not interested in your for orders on a Saturday. For orders, no.
For every single stay, you will have to have 2 for orders.
Done. Tomorrow we'll decide on this for orders on a Saturday. This Saturday. Why are you? Yes, nobody.
I am appearing for not today.
Now see,
Mr. Novinil is appearing for.
Been some
directors of the company has been made a party.
in the mother application, my lord, before the court will it was made a party.
Company has been made a
Made a
party.
party. Along with
Directors
us,
of the
we are the independent directors. We have no
the independent directors of the company which had been impleaded
Eons Limited.
as an offending party in the complainant had not been vicariously liable for dishonor of a check to the extent of rupees
50 lakhs.
50 lakhs. Further submitted that the next date before the trial court has been fixed for considering the plea on 8th of this September. The learned advocate representing the petitioner is to serve notice upon the opposite parties to appear before this court on 8th of September and file an affidavit of service to that effect. The communication, if possible, can be addressed through email also. The proceedings before the trial court is stayed till 8th of September. Next date we fix on 8th of September. Next.
Small intervention. That item number 305, Mr. Nominal is happening. My God, he is on his legs before courtroom number 9. My God, your lordship has recorded that none appears for the petitioner.
So if he's addressing before some other court, his presence needs to be next.
307. 307.
Yes, sure. None appear to represent either of the parties. Let the matter be fixed on 9th of September. Next.
Three 308. Hold on. And for the petition, my lord. Coming up for the first. Being my setting aside of the rejection order of the additional Chief Judicial Magistrate of Ghana, rejecting the application filed under 175(3) of BNS. What happened, my lord? It's long-standing dispute against with my relatives. And the relevant there, some labor works was going on.
Sorry?
There were disputes with my relative. And on the relevant day, some labor works was going on. And I was
You are staying adjacently?
Hello?
Were you staying adjacently?
Adjacent. My lord, I am being a female. I was attacked with bamboo sticks and I was assaulted, and I accordingly made a letter to the police station. My lord, kindly see in page 11. That is the letter.
Physical assault.
Later, after receiving the letter, nothing was done, my lord. Kindly see page
So
number
you did
12,
not receive any cut injury?
12A. Page number 12A. The injury is grave, my lord. Kindly see.
Pain in face just below eye and chest pain.
No cut injury seen because it is my lord bamboo stick, man.
Okay, what is it now? Why have you come?
I have preferred a letter to the SP. Thereafter, I preferred an application under section 175(3). After receiving the application, preliminary inquiry was directed.
Present application is rejected.
Yes. I am coming against that rejection, my lord, because based on the police report, the application was rejected. My lord, kindly see the police report, which should be the
Police report. You serve notice upon the state and come, and on the next state it can be disposed of. Okay. For the submission of learned advocate
the private opposite party,
as well as produced the materials on record. The learned advocate representing the petitioner is to serve notice upon there are private respondents also, opposite party, upon the learned advocates representing the state as well as the opposite parties to be present before the court on the next date of hearing. The learned advocate representing the state is to place the case, the final report.
Police report.
Place the police report based on which the impugned order had been passed. Next date we fixed on 9th of September. To be present before the court. The learned advocate is present. বললাম তো ওটা দেখো পুলিশ রিপোর্টটাকে প্লেস করবে নেক্সট Are you the advocate on record? Then Who instruct? আমাদের এটা কবে to represent the petitioner as well as the opposite party, the learned advocate such and such, ওর নামটা নিয়ে নেবে, submitted to have been instructed by the advocate on record, যার নাম সেটা, to seek time on account of her illness. Next, let the matter be placed before the regular bench. Next. Old matter taken.
My lord, may I beseech before your lordship, I was in, my serial number was 307. I was in different courtroom number. My lord, I beseech.
307?
I was in courtroom number 7 at that time. So by the time I came, it was called, my lord. It is only for the admission hearing, my lord, if it can be done.
কি আছে দেখি? What is it?
My lord, here the petitioner is a civic volunteer, and there is one maintenance petition which was filed by the petitioner. My lord, kindly comes to annexure P1. This is only for the admission hearing, my lord, today.
P1?
Annexure P1.
Which page?
Page number 15, 15.
Yes.
My lord, subsequently, the order dated 31, this petition was dismissed because the petitioner was petitioner was not represented by the learned advocate due to the miscommunication between the learned advocate and the petitioner. And subsequently, the recall was filed on 31st January 2025. Which is in the page number 16. The order is at the last. Only I am before your lordship. I am beseech your lordship. I should be given an opportunity to serve the copy to the opposite party.
No, this is, why have you come here with this kind of a conduct, sir? This is nothing but per se dragging the issue.
No, it is not dragging the issue, my lord.
No, your conduct is writ large in the impugned order as well as the earlier one.
That is what I am. That is the reason, your lordship, I am before your lordship only.
So here also you will get.
No, absolutely not. Absolutely not. Only I am before your lordship is that during the time of the hearing, I will clarify everything. What happened, your lordship? This was in the lower court. There was miscommunication between the learned advocate and the petitioner. And the petitioner and the learned advocate, he was following the online. And in the diary posting, there was something wrong in the diary posting. So because of his miscommunication, the applicant should not suffer. Let an opportunity be given to us. That is my humbly submission before your honor. And he is paying the maintenance also. That has not been denied. The latest report.
Where is the revisional application to have been dismissed? You have come for recalling before you had gone for recalling.
Recalling is, I have placed the order, my lord. That is in the page number 16.
Petitioner.
I will read the paragraph, third paragraph, where it is mentioned, learned advocate for the petitioner has submitted that on that date the advocate was absent. It is specifically mentioned in page number 16. 1616, my lord.
What was the amount of maintenance you were supposed to pay? You had been directed to pay?
Yes, my lord, he was directed to pay and he is paying also, only that.
What is the amount he was directed to pay? So you come to court without even
No, my lord, the monthly maintenance was rupees 4,000. 7,000 he was directed to pay, and rupees
opposite party is directed to make payment of rupees 7,000 per month.
per month.
And for so
It's not a question.
Shivanto.
Chief Legal Advocate. We should attach. Your lordship kindly comes to page 38 of this instant petition. May I read the relevant paragraph?
Now, if you come to page 15,
Page 15.
annexure P1. I think petitioner has no interest to proceed with the case. I have gone through the LCR. I have not found any reason to interfere with the impugned order dated such and such. So now when you have filed the recalling application before the district judge is of the opinion that the order was challenged by the petitioner by this petition was actually order on merit. Without any change of ground, such order should not be recalled.
Yes, but kindly your honor will kindly appreciate the reason or in the order that is also mentioned that the learned advocate for the petitioner has submit on that date was absent. The learned advocate for the so he was absent. Only your lordship kindly comes to page 38 where the amount was decided was 7,000.
The learned advocate
Which is duly paid. Which is duly paid.
The learned advocate representing the petitioner has submitted that the order number 7 dated 31/1/2025 passed by the district and sessions judge Bankura rejecting the prayer to recall the order dated 13/2/2024 had been to the prejudice of the petitioner. Full stop. It was the fault on the part of the learned advocate to appear before to be absent before the court, whereby the petitioner should not suffer. Full stop. The learned district and sessions judge Bankura had opined that the order dated 13/2/2024 was decided on merit, since the impugned order dated 17/8/2023 passed in connection with Miss Case number 72/2020 passed by the learned JM 5th Court, Bankura, was reasonably found not to be interfered with. Full stop. The learned Sessions Judge Bankura is to dispose of the criminal revision number 46 of 2023 with a detailed order citing appropriate reasons for non-interference with the impugned order dated 17/8/2023 in connection with Miss Case number 72 by 2020 passed by the learned JM Fifth Court, Bankura. The order dated 31/1/2025 is accordingly recalled. The learned advocate representing the petitioner is to serve notice upon the public prosecutor as well as the
petition.
who are the other parties?
Private
Nobody else is there?
wife is the other
Opposite party wife
but two.
to be present before the Court of Learned District and Sessions Judge on 16th of September. The maintenance amount of rupees 7,000 as granted by the order dated 17/8/2023 should be continued to be paid by the petitioner to the wife and the child in the proportion as mentioned therein. Error disposed of. None appeared to represent none appeared to represent the opposite parties as well as the state. However, the order passed by this court should not in any instance cause prejudice to either of the opposite parties. Later disposed of, huh? There is judgment from a court. The old matters are it. Old matters for taking.
My lord, my senior Mr. Ghulam Mustafa has not come to the court due to his personal reason. I request your lordship that the matter not be taken up today. Item number 312. My lord, junior of Mr. Ghulam Mustafa.
January 18, January 19, January 20, January 21, January 22, January 24, 5, 3, January 27, January 29, January 30 and 31, January 32, January 33.